On your side, any mentioning?
May my lord's kind leave to mention a matter, my lord. An application for arrest was moved on Thursday. It was heard on Friday. The arrest was declined by the learned single judge.
First granted, then vacated.
My lord, it was not. It was in the nature of an order of injunction.
Sure.
Your lordship's aware. Yes, the injunction was discharged.
Direction for affidavits granted because from April 2024 at least,
Yes,
this vessel has been coming to India.
yes, my lords.
Waited for a year. So what do you want now? You want it to be listed and heard?
Heard today, please, my lord. My lord, otherwise the vessel will sail away. I'm told.
Maybe.
No, my lord.
Come again.
No, there's no certainty it will come again unless Mr. Mujumdar is here. He says this vessel will come again. I have no difficulty.
It has to be listed, Mr. Thakkar.
My lord, kindly keep it on a supplementary list, please, my lords. I'll tell your lordship why.
Not today. Not today.
No, my lord, kindly bear with me, my lord. We mitigated our losses. We were not.
The learned judge has prima facie found that you don't have a case.
So no, my lord, on damage, I'll satisfy your lordship. The learned judge applied.
Satisfy the learned judge.
We could not because the learned judge applied the test that the burden was on us to prove that the damage was caused by this particular vessel. Whereas with the greatest of respect, the law seems to be otherwise, and there was no nobody disagreed with me on the principle of law. But the learned judge held that it is at the stage of trial all these principles will apply. But the matter of proceeding to trial and my ultimately establishing.
What flag does this vessel fly?
Panamanian flag.
Panamanian flag.
Come back tomorrow. Come back tomorrow.
My lord, the vessel might sail away. My lord, it's been filed, your lordships.
The vessel come?
It came on. I was told that it will sail away on the 3rd, but in the course of hearing also it was submitted by them that it would sail away on the 3rd.
It's a feeder vessel which comes from Colombo to Calcutta, Calcutta to Colombo. Last 1 year it has been doing the same.
Yes, but we were not aware that this vessel is not in the ownership of Maersk. We were not aware that this vessel is not in the ownership of Maersk, and we mitigated our losses, my lord. The claim was initially 2.8 million. My lord, the vessel.
Sorry.
Lordship,
we follow some discipline, a procedure, and we don't believe your client, first of all, that he was not aware.
My lord, I'll tell you, lordship.
My lord, tell us when it appears in the list.
Well, may I just for kindly bear with me for half.
It will be listed next week.
Very well.
Tomorrow, jana kono bhul na hoy. Oh, not yet filed.
No, the appeal has been filed, my lord. Appeal has been filed and numbered.
Application has not been filed.
Application has not been numbered yesterday. It has been it's being filed in the department presently. Appeal was numbered. The application was not accepted because the leave was required to file without a certified copy. So appeal has been taken. So my lord, we'll give the.
Who's appealing for?
Well, the appeal has been numbered. Maybe give your lordships the numbers. It can be.
Yes. Give it.
Just it tomorrow, please.
Next.
May I have the lordship need to mention a matter? For inclusion for withdrawal, lordship.
To be mentioned.
Much obliged.
May I?
বুঝতে পারছি চলছে না, আলো জ্বলছে।
চলছে
আলো জ্বলছে। Anyway, yes.
Lordship, my three applications in an execution application, whereby one of the applications has been dismissed with cause, the other two heavy costs have been imposed. Lordship, the same may be listed for as Lordship. I am an intervener in that execution application, and the sheriff has been directed to take possession. Lordship,
Give it.
My lord, IFA for the degree holder. My lord, this is the sub lessee matter, my lord, of the Marshall House.
Oh,
But
that
he is one of the other objectors.
Devottor property.
no, Lordship, no, it's not a
Sub-lessee
trust.
of the sub-lessee. my lord,
Mr.
now.
Abrojit Mitra is appearing.
Yes,
Yes, Lordship.
Completing me, my lord. But the other appeal is listed tomorrow. So if these could be
Tomorrow?
listed together.
Yes, Lordship,
and
if it
one
could,
has not been served. They are mentioning 3 appeals. One appeal has not been
one of them will serve.
Will not take it
We'll
up.
serve it in the course of the day, Lordship. Yes. Grateful, Lordship.
Documents. Command. So it has the hearing का time पे नहीं सुनेगा.
Because of this. So please make the inquiry and find out who is responsible for this. For 10 minutes, 5, 6 judges waiting, 9 judges waiting for a car. This is recently done. This is disruption of court proceeding. Right? Fix the responsibility and take action. Please. Thank you.
May it please your lordship to mention.
Take it.
May it please
Yes.
your lordships to mention a matter for inclusion, my lord.
Please give it.
May I have your lordship's kind leave to mention, this concerns your lordship, the matter Camark Agency Private Limited, which has been listed tomorrow for hearing. Your lordship, paperwork was provided to us and has been filed by the appellant, which contains pages after pages of illegible documents, your lordship, very
Let
difficult.
it be. Hold on. Point out.
My only request is, your lordship, will point it out to them by handing over a list regarding the documents that are illegible. May direction be given upon them to give it to us during the course of the hearing so that we can participate in the hearing tomorrow.
Madam, let it be listed tomorrow. Do whatever you want to do. Write to them. Tell them you don't have legible copies, and then we'll take it up tomorrow. Yes,
Grateful,
next.
your lordship.
Yes,
Can
Mr.
another indulgence, please? My lord, yes, tomorrow is, my lord, an appellate side day.
Very well. We'll do this for you. You're right. Appellate side day. একটা কাজ করো, এটাকে 11:30 ফিক্স করে দাও।
Grateful.
11:30.
Deeply obliged. My lord. Great.
Any appellate side mentioning?
Only said commercial division, item number 1.
We mentioned, I'm the respondent. As a section 9 proceeding. I'll tell you in brief.
Why to be mentioned?
I'll tell you why. You'll give me 30 seconds time. In a section 9 proceeding, I was the petitioner. The section 9 single bench passed an order upon the respondent to secure.
Here you are respondent.
Yes. To secure 5.85 crores in the bank account, keeping that money separate, he can operate the account. The respondent, single respondent in that position. Now, against that order, the respondent preferred an appeal, which is the appeal bill. In the appeal court, they said that, please, the bank account should not be blocked. They offered 2 properties, 2 flats. So offered as security. The 2 flats as a security. In addition, they offered a personal guarantee of one of the directors of the respondent company. The registrar insolvency was directed by the Honorable Court to value the properties, accept the guarantees, and take necessary steps. Register. It was done by the registrar. some proceedings were initiated with the registrar. Now, before the registrar, we found a affidavit of justification was filed by them. The guarantee papers were given. 2 flats valuation was done. Now, when a valuation was done by a registered valuer, we find that the valuation of these 2 flats are coming around 2.5 crores odd. 2.5 crores odd. Now, before the registrar, the difficulty that arose, my lord, is that they say the interpretation of the order is that now the registrar has brought the matter before the court because there was some dispute before the registrar. The registrar's order records that the late is filed before the court. And then we mention the matter also.
কোথায় ফাইলটা কোথায় কি রেজিস্ট্রারে কি আছে দেখি লে নোট ফে নোট আছে the appeal court had allowed them to secure by way of property.
Now this
5.86 crore.
5.85.
The valuation of these 2 properties has been made by whom? By a valuer.
Panel.
And 2 properties taken together are valued at 2.5.
Yes, approximately, maybe 2.6, 2.8, whatever. It's 2.58.
Then, Mr. Medora,
now, then what they do now thereafter, now not only that, they say, so for the balance of 5.85 minus 2.58, the balance they will give a personal guarantee. This was not the object of the appeal court. The entire money has to be secured. This is number one. It cannot be split today. Secondly, I find from the affidavits filed before the registrar, we find even those flats are not
order ফাইলটা দাও অন্তত কি অর্ডার ফর্ডার আছে দেখি
আচ্ছা ইনকাম্বার বলছো হ্যাঁ দ্যাটস হোয়াট আই শুন দ্য এলসি ফ্রম আইডিবিএ
এক কপি আছে
আমার ফাইল না 25 হ্যাঁ 24 and 25 সেকশন দ্য 883 ঠিক ওটা জাস্ট সাথে
but I have a copy of it. This is the last order of the act.
No, show us the parent order of the appeal court whereby
Well, I have prepared a compilation of those orders as well as the proceedings before the registrar insolvency. If it helps your lordship, I can hand over 2 copies of the same.
we are not hearing the matter, Mr.
Very
Madura. 18 November.
I had a copy.
To the extent of 5 crore.
Not 5.85.
5.
Okay.
I have a problem with everything. That is not easy. The concept is given authority to the release of charge by TCL bank of settlements and action. TCL take by jurisdiction. Comfort.
Issue? By an order dated November 18, 2024, a coordinate bench had disposed of the appeal by directing the appellant and its direct appellant and its directors to furnish security to the extent of rupees 5 crore to the satisfaction of the registrar, original side, without prejudice to the rights and contentions of the appellant. Stop. In the said order, the coordinate bench also recorded the submission that was made on behalf of the appellant that 2 flats measuring 1505 square feet and 1510 square feet would be offered as security, and further a personal guarantee of one of the directors of the appellant, Mr. Nokul Himatsinka, shall also be offered to secure the sum of rupees 5 crore. It doesn't talk of the difference, Mr. Medoda. Look at the order later.
Yes, it doesn't, but well, I'll come back later. The aggregate
Paragraph.
must be 5 crore. That is my submission.
Paragraph. Really, they are not interested in the personal guarantee. Need not also, we can modify that order also.
Yes, it so appears, because I'll tell your lordship, what they are doing in the arbitration is they have impleaded Mr. Nakul Himatsinka as the respondent number 2 because of the personal guarantee. So they are playing it both ways.
Otherwise, we cannot enforce it again.
At one level, they are not accepting the personal guarantee, and on the other level, they are relying on it to drag me into the arbitration.
accepting the valuation of the flats.
And that is not used to drop this point as legal guarantees, not enough. It appears that the learned registrar in insolvency, bracketed in charge, by an order dated January 22, 2025, requested that the matter may be placed before this court, since there is a disagreement between the parties as regards the form in which the sum of rupees 5 crore is to be secured. Stop. The paragraph. The respondent says that personal guarantee of Mr. Nakul Himat Singh means nothing. Stop. The security must be real. Stop. Stop. Comma. Either in the form of real property or cash.
And my lord, one more thing, that the respondent number is almost going into CIRP. If if the Nakul Himat Singh does not give the personal guarantee, we will be unable to enforce the award.
He must make up his mind. What does he want? Does he want
Then take the personal guarantee.
Yes.
Lord,
In
otherwise,
Be
arbitration,
happy with 2.5 crore
Yes.
property and take his
in
personal guarantee.
arbitration, it is submitted. Nakul has all the money, therefore we
No,
want
no,
the
wake
personal
up your
guarantee.
mind, sir.
as per the order, they need to secure it to the extent of 5 crores. which
Yes.
is-
So 2.5 crore they are giving property, 2.5 they'll give
but
personal
there is no
guarantee.
segregation in the order, my lord.
Then take 5 crores personal guarantee.
But if they,
Sir, we are not sure you know what you are saying. So please consider and come back. You
Either in the form of real property or cash.
or at least
Arbitration, they said he has the money.
unconditional irrevocable bank guarantee. Stop. Paragraph. List this matter once again on Horseshoe date the other. Top learned advocates for the parties are requested to come back with better instructions.
Grateful, my lord.
the leave be given to file a wakalatnama, my lord. Since the appeal
Why
is disposed of-
here?
Since the appeal is disposed of, the department is not taking the wakalatnama, my lord, and the affidavit of competence. My lord.
The near now. Leave the other. Leave is granted to learned advocate on record for the respondent to file wakalat. গুলিয়ে এবারে কেউ কিছু জানে না. You don't even know whom you're representing.
My lord, I appear for the appellant.
Yes, we are clear in our mind. Record for the respondent to file wakalatnama in court. In court, na in the department. In the department.
Grateful.
Item number 2.
এটা আবার কেন? Written note বোধহয়.
Your Lordship, Your Lordships, may I be permitted to point out 3 important aspects which are.
It was listed only to file written
Yes, Your
note.
Lordship, I filed the written notes. I'll just point
That's
out.
all, no, madam. No further argument today.
Your Lordship, a question fell from the bench. That,
Whatever the question, we withdraw that question.
Your Lordship, I've provided the answer in the written notes of argument.
You have said whatever you wanted to say in your note, and we are sure.
Yes, Your Lordship. Just,
Fine.
Your Lordship, so that the other side doesn't live in surprise. That's why I wanted to point out this particular point regarding the accounting point that was taken into consideration. That, Your Lordship, the auditor mentioned that the company, the plaintiff, does not have or did not declare any intangible asset. That was a very in the balance sheet, Your Lordship. Unfortunately, this is an irresponsible argument, and we will be providing Your
Who
Lordship.
is the plaintiff?
Your Lordship, I am appearing
You're
as the
the plaintiff.
respondent and the plaintiff in the suit.
Okay.
He is appearing for the appellant, who was the defendant in the suit, Your Lordship. And now, Your Lordship, an argument was made that the auditor stated that this company, that is a plaintiff, does not have any intangible asset, thereby questioning my ownership. First of all, Your Lordship, there is no relationship. Second of all, the question is what kind of intangible assets are to be recognized in terms of the Indian accounting standards? Indian accounting standards was introduced in 2015, Your Lordship, and under Indian accounting standard of 38, it is clearly stated an intangible asset, if it is identifiable, then it has to be recognized. My mark, Your Lordship, is not identifiable. Why? Because, Your Lordship, it cannot be separated from the company and separated from the goodwill. Second consideration, Your Lordship, is that when it comes to a calculation of the goodwill, it has to be on the basis of reliable sources. Therefore, this entire calculation, Your Lordship, is extremely difficult for any chartered accountant or any auditor to come to a conclusion. I've marked the portions for Your Lordship's perusal.
Very well. Thank you.
Great.
You have filed your note.
Yes, on the last day, I had.
Written Lekho. Written notes of argument filed on behalf of the respondent. They are the respondent.
But I am the defendant in the suit, the appellant. They are the
Filed
respondent.
on behalf of the respondent. Be kept with the records. Paragraph hearing is concluded. Stop. Judgment is reserved.
Grateful.
Item number 3.
Number 3, Your Lordship, I'm praying for a short passover. I'm being led by.
Passed over. Chalo.
That in that event, will Your Lordship be pleased to make it not today because I
You've
will
got a
be
bad cold.
very bad cold.
In this heat, a bad cold. Yes. What do you want?
But, in that case, even if Your Lordship keeps it tomorrow, my lord, I will be stuck in some another.
Then day after tomorrow?
Yeah.
Come back. Not today and tomorrow.
Mr. Basu is already on his way. He will be joining us in a few moments.
ওকে সকালবেলা ফোন করেছিলাম so that আমার জ্বর হয়েছে and
Item number 4.
ওই জ্বর হয়েছে। 4.
Lordship, item 4, Your Lordship, I am for the appellant, Your Lordship. In that matter, Your Lordship, we wanted to start, Your Lordship, in that section 12A leave, Your Lordship, has been revoked.
Yes.
And Your Lordship, the suit has been dismissed.
Yes.
Now, Your Lordship, may Your Lordship, Mr.
Yes.
Bush, today is
No,
here.
Argue. We have read the judgment. We have read the judgment.
Lordship.
Perfect. Tell us what you have to say.
Yes. Lordship, one thing, Your Lordship, that Lordship, this particular judgment, Your Lordship, has opened, Your Lordship, the window, Your Lordship, in Yamini Manohar's judgment, which clearly said that section 12A leave on the basis of a contemplation of an urgent relief, Your Lordship, is based on
Yes.
Is based on, Your Lordship, the plaint, averments in the plaint, and contemplation of an urgent relief. What actually has happened, Your Lordship, when we filed the suit and obtained the leave under section 12A, at that point of time, Your Lordship, we have presented the entire facts. We obtained, Your Lordship, an ex parte, Your Lordship, order. Against that, Your Lordship, the both parties, Your Lordship, consented.
Mr. Shengupta, the learned judge has, on the basis of material, come to a finding that if not in 2018,
Lordship.
during that Kishan Fair or whatever it was,
Yes.
at least in 2022, you had knowledge.
Yes, Your Lordship.
And therefore, there is no question of urgency. And that is why, you see what happens when this leave is sought for. Which learned judge has the time to spend 1 hour going through the material and seeing whether in fact there is urgency or not? Learned judge relies on the submission made
It's a trust
from the
between,
bar.
Your Lordship, the plaintiff and Your Lordship. the-
Later, in many cases, it transpired that the statements made in the plaint or trying to show urgency are baseless.
Lordship.
This is
Now
what
the-
has happened in this case.
Exactly, Your Lordship. Now, Your Lordship, the question is whether the materials which came before the Honorable Court is such, Your Lordship, which actually, Your Lordship, allowed you, the Honorable Single Judge, to revoke the Section 12A leave, Section 12A, and rejected the entire suit, and Your Lordship vacated
We are
the
hearing
entry.
the appeal, have to hear the appeal out. All papers are before us.
Lordship, all papers are before Your Lordships. Today, Your Lordship, I want to, Your Lordship, only show, Your Lordship, the judgment and, Your Lordship, the purport. The reason, Your Lordship,
If we are
were
not
enjoying-
hearing the appeal today, why?
The reason, Your Lordship, that the interim order, Your Lordship, which was subsisting at that point of time, and what happened, Your Lordship, the interim order has been vacated. On the basis, your lordship, the section 12A leave, your lordship, has been revoked. May I, your lordship, indicate only one thing? Your lordship, this particular two material factors which your lordship has seen from the judgment. One is the Kisan Miller, and the second one, your lordship, is the
Tomorrow, the appeal.
tomorrow.
Tomorrow is an appellate side day. Normally, we have a very few appellate side matters.
Lordship.
So after that, original side list is called on.
Lordship.
Provided you have all papers.
All papers, entire papers. I'll provide that. No
Provide
problem.
that. Esho. Yes. This appeal is directed against a judgment and order dated March 20, 2025, whereby a learned judge of this court revoked the leave.
It should be dispensation because 12A doesn't contemplate any leave.
Correct. Revoked the order dispensing pre-suit mediation, dispensing the requirement of pre-suit mediation. Stop. Pre-suit mediation in terms of Section 12 capital A of the Commercial Courts Act. Stop. Consequently, the plaint was rejected and all interim orders stood vacated. Stop. The defendant, the plaintiff has come up by way of this appeal. Paragraph. We have to hear out the appeal. Stop. We are told that all papers that were available before the learned single judge have been annexed to the stay petition. Stop. Let an informal index be prepared. Stop. Paragraph. List them as agreed by and between the parties, as agreed by and between learned counsel for the parties. As agreed by and between learned counsel for the parties, list the matter tomorrow, Mr. Bachawat?
Yes, not done.
Kalki date diye dao. And that were available before the learned single judge have been annexed to the stay petition filed in this appeal. List the matter, Kalki date dao, as the first item under the heading appeal from orders. We have expressed our mind to your junior.
But
he may convey that to
it's
you.
a short matter. We could have finished it in half an hour today only. So I was just asking why it's been kept.
That
tomorrow.
index will be helpful, maybe.
Hello?
Informal index.
We have a, oh, I see. Very good. Very good. Very good. We will come. We'll come back
tomorrow.
Item number 8.
As agreed থেকে নতুন sentence. তার আগে let an informal index be prepared.
Item number 5, 6, 7 তো ডেট হয়ে গেছে। Item number 8. I appear for the respondent. This is my application. Miller or Miller order impugned before your lordship is arising out of a affirmation of a Miller award passed by the learned arbitrator so far as the counter claim is concerned. Prior to going to the impugned order, Miller, just in a nutshell, Miller, I am placing. Miller, 2 application has been filed at the instance of the claimant, 34 application at the instance of the respondent. So far as the application filed by the claimant is concerned, that is, Miller, challenging the awarding of the counter claim only.
so far as the respondents section 34 challenge is there, this is pertaining to a typographical error as alleged in the Milord the award and in the Milord the corrected award which has been passed on an application under section 33.
Yes.
Therefore, Milord, if Milord the counter claim is allowed, in that event, so far as the claim which has been awarded in my favor, so far as the security deposit is concerned, that should not be allowed because it is intertwined. But it appears from the impugned order before your lordship is based on no evidence, affirming an award which is based on no evidence, and contrary to the clauses of the contract.
You are who? Huldia?
Milord, I am Milord the
Konark?
yes, Konark Enterprise.
You are the claimant.
Yes.
Award was your claim was allowed.
So far as the security deposit is concerned, that has been allowed in my favor.
Yes.
So far as the Milord, the counter claim is there, which have been filed by my learned friend, that has been allowed. The quantum was less. Subsequently, that has been modified in the section 34 application to the tune of rupees 50 lakhs and odd figures. So I am not on so far as the Milord, the quantum is concerned. I am on so far as the principle on the basis of which counter claim has been awarded based on no evidence. Should I place Milord the impugned order first, or Milord I will place my the fact? I will place few documents where from your lordships, Milord, I would be able to impress your lordship that
We are
this.
trying to read. You can see that we are trying to read.
Sorry,
Mr.
sorry. Extremely sorry. Extremely sorry. Paragraph 20 to 35. আসেনি application?
Yes, it was a computational error which the learned judge has corrected. Nothing on merits. The figures are already admitted.
May I submit?
Make your submission. Make your submission. Please be as brief as possible, Mr. Dotto. There's several matters running in the list.
Will you kindly have a look at, my lord, page 6 of the impugned order. Pen.
Your application has not come. When did you file it?
Previous Wednesday.
Huh?
Previous Wednesday.
কেন আসেনি? বুধবার ফাইল করেছি বলছে। You need to point out certain papers in the application.
My lord, kindly, my lord, I intend to place, my lord, impugned order first, and thereafter I will go through the documents.
So what document? We don't have the documents. The application is not here.
So kindly fix any date. My lord, if your lordship pleases, my lord, only I point out certain things in the impugned order from the memo today.
No piecemeal. Either finish it off today then.
So if the paper should not be there, my lord, how that can be?
Not today.
Item number 9. My lord, can it be on next Thursday? Because
This week Thursday or next week Thursday?
no, this Thursday.
Yes, Thursday. Who was on the other side? কে ছিল?
Hey.
Thursday.
Item number 9, it is my appeal from an order which has been passed in a section 9 application. Right, my principal ground is there ought to have been a prima facie satisfaction of the existence of the arbitration clause and the fact that there is an undisputed arbitration agreement between the parties. Only then an order under section 9 could have been passed. But on the first day when the matter was taken up, on 23rd December, I was represented. I am from Tamil Nadu, from some village in Tamil Nadu. I appointed a lawyer from Chennai. He appeared and submitted that there is no question of any order being passed because the property in question is already mortgaged to the bank. On the second day, that is the impugned order, when this matter was taken up, I was not represented. The section 9 was allowed by restraining me from creating any third-party rights in respect of the property is concerned.
Yes, this was passed in your absence.
Passed in my absence.
Go before the learned judge. You chose not to appear.
Yes, my lord, that was our mistake.
Order 9, Rule 13.
Yes, but my lord, on the first day I appeared, so it may not have.
Yes, but on the day the matter was passed, it was ex parte.
Yes, that was ex parte.
The learned judge. Why should we interfere?
My lord, only thing is that, my lord, the order was passed on 19th February.
Yes.
The order is of 3 months. But it is going to expire on 18th May.
Client chose to sit over the matter.
But I'm not joining any issue there. But the only thing is that they have initiated an arbitral proceedings. They have issued a notice on us, a notice under section 21, as well as a notice from the arbitral tribunal itself. Well, the only thing is that may I pray for some liberty or some observation from your lordship so that I can address whatever my points are insofar as the existence of arbitration clauses
to the arbitrator.
Before the arbitrator or before the appropriate court. Only when this observation will suffice. But I understand, my lord, this appeal may not have much scope, but this observation may suffice.
Issue. This appeal is directed against, by consent of the parties, the appeal and the connected application are taken up for hearing together. Paragraph. This appeal is directed against a judgment and order dated February 19, 2025, whereby the respondents' application under Section 9 of the Arbitration and Conciliation Act, 1996, was disposed of by restraining the present appellants from dealing with, transferring, alienating, or changing the nature and character of the secured assets. Secured assets. Stop. Paragraph. Learned advocate for the appellant says that before the impugned order was passed, the learned judge ought to have recorded at least a prima facie satisfaction of the existence of an undisputed arbitration clause, and that there is a prima facie case for granting an injunction. Stop. The same not having been done, comma, the order impugned ought to be set aside. Paragraph. We see that on the day the impugned order was passed, comma, nobody appeared for the present appellants before the learned single judge. Stop. The learned judge noted that on an earlier occasion, a learned advocate had appeared through video conferencing facility, but on the day the impugned order was passed, comma, the appellants herein, being the respondents before the learned single judge, comma, were not represented. Paragraph. Since the appellants herein chose not to appear before the learned single judge on the day the impugned order was passed, comma, we are not inclined to interfere with the order. Stop. This will not prevent the appellants from approaching the learned single judge with an appropriate application, comma, if they are so advised. Stop. This paragraph. This order will also not prevent the appellants from urging all points, including the point of existence of a valid arbitration clause, before the arbitral forum or any other forum that may be available to the appellants in accordance with law. Next, appeal and application disposed of.
Grateful.
Item number 10.
But I'm praying for a short passover. Mr. Mistro is appearing in court number 36. He's arguing the matter. He requested for a short passover, man. No, exactly. He was in the impression the matter will happen top of the list.
Just fix that you're there instead.
Yeah, of course. Yeah.
Just fix one in the morning at
But he's
who is stuck?
Mr. Joyanta Mitra. He's just in the court number 36. He's arguing on one matter.
Yes, so we can pass it over, but
yes.
Pass it over.
Yes.
এই একবার দাও তো মেমোটা খালি দাও কাল কি বলবো
Item number 11.
I have to make the same prayer, my lord. I am led by Mr. Jayanta Kumar Mitra, my lord. I am for the appellant. It's my section 37, my lord, challenging an order on section 34, my lord, rejecting my petition for, my lord, setting aside of the award. So, my lord, I'm praying for a short passover, my lord. Mr.
Passover because Mr. Mitra will first argue
yes,
the previous matter.
Yes, my lord. Yes.
Passover.
Yes.
Item number 12 and 13.
My lord, I am for the appellant, my lord. My lord, my senior counsel, Mr. Shyamul Chakraborty, is admitted in the nursing home for an operation, and that's why he will not come. Kindly keep it after vacation, my lord. Kindly.
Maybe file our affidavits, my lord. We were directed to file a clarificatory affidavit. My lord, in a nutshell, my lord, I do not stand in the view. Your lordship will keep it, my lord, as and when commensurate to your lordship. But, my lord, they wanted to settle the matter. There was a direction passed by Honorable Justice Sen, the erstwhile division bench, my lord, where we were asked to, my lord, bring on record what is the status of the vehicles under the agreement. And they were supposed to, my lord, tell us how they are going to pay the amount. It's a simpliciter case of, my lord, financing. And, my lord, they now say that in a claim which is in excess of 1 crore 20 lakh, they want to settle at 11 lakh. My lord, we are not agreeable to such settlement. Whenever Mr. Chakraborty is well and fine, Let him come and address the merits of the matter. Settlement cannot take place. May that be recorded.
Yes.
My lord, affidavits are exchanged. Affidavits are exchanged. Ready for hearing. Okay.
How do we describe this affidavit? Affidavit in opposition. What have you filed? Reply. ও তো respondent to a reply file করবে।
This is, my lord, the affidavit in reply filed on our behalf.
My lord,
Justice Sen wanted us to file an affidavit stating what is the amount.
I've understood.
They had opposed and this is the reply.
Affidavit dated May 2, 2025, filed on behalf of the respondent. We kept with the records. Paragraph, Mr. Banerjee, learned advocate, appearing for the respondent, says that there is no possibility of an out-of-court settlement in this matter. Stop. The claim of the respondent is in excess of rupees 1 crore. Stop. The appellants are willing to pay only about rupees 11 lakh. Stop. Paragraph, accommodation is sought for, adjournment is sought for. Adjournment is sought for on behalf of the appellants on medical ground of learned senior counsel appearing for the appellants. Paragraph, as requested on behalf of the appellants, list this matter once again on June 12.
June 12th. Okay. Grateful, my lord. June 12th.
Item number 14 and 15.
Passover. Oh.
For the respondent.
Passover.
Item number 16.
Lordship, in item number 16, I am for the appellant, your lordship. I was praying a week's time in this matter. With the appeal is ready, your lordship. Paper books has also been filed. But
you are for the state.
I'm for the state. We won the suit.
This is with my suit.
I think the only one that's
Money claim.
Money claim, your lordship.
Very well. Accommodation is paid for.
The friend will confirm my state's instruction of paper books haven't been served.
Your lordship, paper book has been served.
If not, then give them.
I will, but I have served it as per my knowledge goes, your lordship.
Then let it come.
After reopening.
It has not been favored together.
Yes, yes. The appellant's suit was dismissed by a learned single judge. Stop. Learned advocate for the appellants, more than one appellant, only one appellant, for the appellant says that paper books are ready. Stop. He seeks a week's adjournment. Paragraph, the summer vacations are coming up. Stop. We do not see any urgency in the matter. Paragraph, list this matter immediately after reopening of the court, after the ensuing summer vacation. Stop. In the meantime, let copies of the paper books be made available by learned advocate on record for the appellant to learned advocate on record for the respondent. How's life treating you?
Deeply obliged.
Item number 17.
Item number 17, my lord, kindly pass over this matter, my lord.
You're for the appellant.
Yes, Devjani Ghoshal, my lord, senior.
Do you know on whose behalf you are making this prayer? Appellant or respondent?
Appellant, my lord.
Very well, pass over.
My lord, kindly fix 2 p.m., my lord.
On Saturday.
13 minutes.
Pass over, second call.
Passover matter, item number 10.
Award holder.
My lord, he's still in the court number 36. Huh?
We are happy to hear you, but then tell us something. What do you want?
My lord, in that case, I'm constant to mention that only, not today.
Not today.
Because
Very well. Chalo, not today. Chalo.
Item number 11.
May I pray for the matter to retain its position, my lord, item number 10.
Yes, nobody will change the position. Don't worry.
it will come Wednesday.
Not 11.
My lord, I could, my lord, give a brief overview of the matter if your lordship so desire.
No. Ineffective. If you finish it today, we are happy to hear you.
Then, my lord, kindly, my lord.
Not today.
Item number 14 and 15.
Yes, who's for the respondent? Appellant? Mr. Singhania? Yes.
Should we start today, my lord?
Sorry?
Not fully ready with them. Actually, with the
Last time also you said the same thing, Mr. Singhania.
last time I got the briefs. Just 2 days back, I got the briefs. I called the client also, my lord.
When will you get ready?
Another 1 week.
Another 1 week. Sure.
Sure, I'll do it.
13. Accommodation is paid for on behalf of the action করবে হ্যাঁ 14-15 behalf of the appellant. Stop. Let these matters stand adjourned and be listed again on 12th or 13th. Oh, right. 13th. May 13th.
No.
Appearance now, appearance.
Item number 17. এইবার নন কমার্শিয়াল চলবে 70টা কি হয়েছে ভিড়া
Yes.
Item number 17, my lord.
কি ডাকলে 17? Yes, madam.
My lord, kindly not this week.
Not this week. Why? Why are you looking so sad? Who is your senior in this matter?
Devjani Ghoshal, landed advocate Devjani Ghoshal, my lord.
Not today, we'll do.
13 May, my lord.
13th May. On the prayer made on behalf of the appellant. Dikcho. Let this matter stand adjourned and be listed again on May 13th.
Non-commercial matter item. Non-commercial matter item number 1.
এই টু বি মেনশনড কেন এসছে এটা? Settlement. Parties are trying to settle. এই সোমালি মুখী সঞ্চিত চলছে। বুঝলাম তো, পাসওভার করে রাখো যদি এসে যায়।
Item number 2. I'm for the official liquidity of the respondent in this matter.
Milord, I'm for the appellant, Milord. I'm praying for a short passover, Milord. Mr. Sarvapriya
Very
Mukherjee
well.
is
May I,
on legs.
may I Milord, take your lordship's leave to file a supplementary affidavit because a long pending matter. I'm only seeking 7 days time.
Yes, better. If we have to, we thought they will not appear, but since they are appearing, অনেক কি development হয়েছে।
My lord,
This,
my lord, on the previous occasion, the erstwhile advocate representing JP Trading was asked to appear before this honorable court, my lord. My lord, I am the junior of Miss Shanchari Chakraborty. She's on legs from NCLT. My lord would kindly pass over the matter for 2
we are
minutes.
only calling for an affidavit from the OL's office.
My lord.
This is a long pending matter. Stop. Learned advocate for the official liquidator says that after filing of this appeal, there has been developments. Stop. He seeks a week's time. He seeks a week's time to bring on record such developments by filing an affidavit. Paragraph. Let such affidavit be filed before the next date. On the next date with advance copy to learned advocates for the other parties. List the matter next আজকে কি বার সোমবার 13th.
Milord, one indulgence. Milord, we have filed an application, Milord, ACO number 4 of 2023. Milord, it is praying for liberty to file Bagalatnama on behalf of the appellant without the no objection, for which my learned friend is appearing, Milord, the erstwhile advocate on record. Milord, this application is also pending, Milord. If a copy may be served upon us also, Milord.
No, you appear for whom? APJ?
JP Trading.
She also appears for JP.
Yes, Milord. They are presently on record. Milord, they have not given no objection to us. Milord, we have been instructed to appear on behalf of JP Trading. Milord, that is why
No,
our
why will
application.
we do not know. Maybe their fees have not been paid.
Lordship, I am Shanti Chakraborty, Lordship. I am the advocate on record, erstwhile, Lordship. In this matter, Lordship, this appellant, we did everything, Lordship. Fees are due. We have been requesting. In fact, we had requested Mr. Ghorai also that we will issue no objection. If your Lordship will bow down before your Lordship. During 2020, during COVID period.
Madam, we have only called for an affidavit from the OL. We have done nothing else. We are not granting them any leave. They are asking for leave to file without no objection, this and that.
Lordship.
We know. We are doing nothing. Come back on the 13th. Consider their affidavit. They will give you an advance copy. And we will only give to the advocate on record, not somebody claiming to be.
Item number 3.
I'm for the respondent, Lordship, with item number 3 and 4. Lordship, this matter is appearing after a long time, Lordship. I need some time to prepare because.
No, where is the appellant?
Your Lordship, I appear for the appellant.
Yes.
I am led by my senior, Mr. Rupak Ghosh and Mr. Chayan Gupta. Both are on legs before different courts. Can you kindly grant me a short passover?
Lordship, can it be fixed after 12, Lordship? Lordship, what happened in this matter, Lordship? This is a long pending matter. There is no stay order in favor of the appellant. Lordship, in the execution, we
Money decree.
Money decree of almost more than 60 lakhs. Lordship, may I place the execution order, Lordship, once? Lordship, they have pleaded there again and again. They have pleaded that they have asked for the mediation. They were ready to pay. Now they have not paid a single penny. They have not paid the entire amount, though they have. Lordship, kindly see the order in the execution.
Just now you wanted adjournment and now you're opening papers.
This is a long drawn process, Lordship, and I'm praying it's kindly fix this matter after
13th. Accommodation is paid for on behalf of the parties. Paragraph. List this matter once again on May 13.
Grateful, Your Lordship.
3 and 4.
Passover matter, item number 1.
I am for the appellant, my lord.
Is
This
it
matter.
settled?
Yes, my lord. This is eviction proceedings, my lord. The tenant has surrendered the possession. We have got the.
He's filing terms of
Yes,
settlement?
my lord.
Bah.
Hmm. I'm waiting for the respondent. my lord.
Very well settled. Learned advocates for the parties tell us that the matter has been settled out of court. Stop. Terms of settlement filed in court today, comma, signed by the parties and their respective advocates, comma, be kept with the records. Paragraph. The appeal stands disposed of accordingly.
Oh, bless my lord. The suit may be, my lord, disposed of.
Huh?
Suit may be disposed of, my lord.
Suit also.
Yes,
Acha.
my lord.
You have said so here.
It's not.
ডিসপোজ হতে ওরা বলছি যখন রেকর্ড করে
No, it's not in the terms of settlement also, my lord, but this is the eviction suit. Suit has
your
been.
suit, your suit.
Yes, my lord, my suit. Eviction suit, the possession has been given.
Paragraph. Learned advocate for the plaintiff, oblique appellant, and you are the appellant here.
I am the appellant here, my lord.
Appellant.
Yes, my lord.
Plaintiff oblique appellant says that in view of then suit is pending still.
Suit is pending, my lord. This is an application under Order 12, Rule 6, my lord. We prayed for judgment upon admission, and thereafter, my lord, being my lord.
Says that in view of the settlement between the parties, comma, the suit may be disposed of.
Yes.
Stop. What is the suit number? CS number 405. CS 405 of 2013 is treated as on days list and stands disposed of.
Decree may be passed, my lord, as per the terms.
The decree may be drawn up expeditiously.
Please, my lord.
Item number 5.
But this is an application for restoration of appeal. Well, this was taken up on last Friday and your lordship had sought a report. But this is that matter where the APO was dismissed for default and the APOT number survived. Blood an order of stay was passed in
Order filed to the
Lord, we've annexed it to our petition.
Junior. Which is the relevant order?
Lord, the relevant order is of 4th March. Lord, that starts at page 66. 66. Lord, by way of this order, we were granted leave to file an application for restoration. Lord, if my lord kindly takes paragraph 9 at page 67.
The bank guarantee has been invoked.
My lord, the bank guarantee, my lord, because of delay on our part, the learned division bench, my lord, was pleased to invoke the bank guarantee and direct the registrar to keep it in a separate fixed deposit. My lord, subsequently, we've also furnished a fresh bank guarantee, which is valid till 16th August 2025. My lord, this was done pursuant to an order passed in GA2, my lord, which the order dated 27 November 24, which appears at page 60. My lord, an application for stay was filed. My lord, order of stay was granted in 1998. My lord, subsequently, we had given bank guarantees which were furnished from time to time. My lord, in 2005, the APO was dismissed for default. My lord, in 2011, we filed another application for furnishing bank guarantee because we were admittedly out of time. My lord, this was allowed by an order of 16th August 2011. My lord, this was not before the parties that the APO had been dismissed, but the order was passed granting us liberty to file fresh bank guarantee.
Sir, today this application is for restoration of APO.
Yes, my lord.
343. The coordinate bench granted you that, in fact, directed you to file an application for restoration. In the same order dated 4th of March 2025, the division bench directed encashment of the bank guarantee and for keeping the proceeds in a separate fixed deposit. Has that been done?
Yes, my lord. My lord, the letter of the registrar is at page 81. So the learned registrar was directed to do this, not at page 81.
This is only the letter of invocation. Do you know whether the proceeds have been paid under the bank guarantee?
My lord, the proceeds were not directed to be paid, but to keep it separately in a fixed deposit.
That's been done. Do you know that?
Yes, my lord. My lord, page 81.
This is the request. Was this request complied with? Anyway, কথা বলে লাভ নেই বেশি। Just restore করে ছেড়ে দিই আর কি করবো? Very sure.
রেজিস্টার বলতে পারবো রেজিস্টারের ব্যাংক গ্যারান্টি করে পাঠিয়ে দিয়েছি সেলফ প্রসিক এটা তো রেজিস্টার বলতে পারবো
Order dated March 4, 2025, passed by a coordinate bench. Stop. Paragraph. In terms of the direction contained in the said order, comma, the present application has been filed for restoration of APO 343 of 1998, which was dismissed for default on August 16, 2005. Stop. Paragraph. You are all for ECL. Where's your other side? Have you served?
Yes, my lord. My lord, have tendered the
The Sanctoria PO. দেখি অ্যাফিডেভিটটা দাও সার্ভিস হয়েছে কিনা দেখি
They've appeared.
27 March appear.
How have you served? By post?
By hand.
By hand.
Well, they've appeared on 27 February and 4th March. The last orders passed in this matter.
All right. We have heard learned counsel for the applicant, Eastern Coalfields Limited. Stop. We are satisfied with the explanation furnished for absence of learned counsel for the appellant on the day the appeal was dismissed for default. Paragraph. Accordingly, comma, the order dated August 16, 2025, 2005 August 16, 2005 is recalled, stop. APO 343 of 1998 is restored to its original number and file and number, original file and number. A GATA is disposed of.
Great one.
I would have sought for not this week in the next.
For the appellant.
But I would like to but I would like to file an affidavit, but there's a condonation application, but
What application?
3 days.
what else?
In presenting the appeal. You want to oppose that?
But the reason
It's not medical ground, rheumatism is fixed.
yes, rheumatism and blood sugar. If that has been the case, then I wouldn't have been able to come to court. But if I can do it, then the person can also do it.
Are you seriously opposing?
But I've been told, madam.
You've been told. লেখো এটা order করে নাও তাহলে GA1 is that is your condonation GA1
No, it's a composite application.
oh right original side
Original side, there's no prayer for stay. Obviously,
There's no question of stay.
No question of stay. If you suit this way.
দেখে নাও এবার কাগজটা দাও we want to be sure that none of us was ever connected with this matter particularly my brother yes that is right ওনাকে দাও আমি কিছু বুঝবো না দেখে
This is, if I may give a short background, this is with regard to a person who says that he used to work in the electric department, he was present in a field, and that there was a, the CSC went out for trying to cut off all illegal connections, where this person was assaulted, and a police case was started against him, and for that, malicious prosecution. If this gets back some kind of memory.
So his suit for malicious prosecution was
Not
dismissed.
technically, my lord. That is the
They
case.
say it's not a.
That is what the learned single judge, my lord, has also said. But mine is a case for damages based on injury caused, both physical as well as injury to the business.
Suit, no malicious prosecution, and on the grounds of limitation.
No, it's a different kind of suit. Interesting. You don't get to see these suits these days.
That is correct.
And trust Mr. Arindam Paul to produce such a suit.
Although he's a new entrant.
New entrant. We will direct exchange of affidavits on the issue of condonation, but we request both parties to kindly do some research and find out whether or not my lord was involved. Huh? There's a delay of
3 days.
3 days in presenting the appeal against a decree whereby the appellant's suit was dismissed. So, Mr. Roy, learned senior counsel representing the respondents, says that he has been instructed to pray for time to file affidavit opposing the condonation prayer. Paragraph, let affidavit in opposition be filed within 1 week after summer vacation. Date ta diye debe, 16 June 16. Stop. Reply thereto, if any, be filed within a week thereafter.
2 weeks.
Within 2 weeks thereafter, date ta diye debe, 30. Paragraph, list the matter on the following working day.
Keep love.
The appeal, claimant in the reference was a MSN. Hence, the arbitration could not have taken place like a regular arbitration, but it has to be taken place before the MSME council. The registration of
So you are the claimant.
I am the respondent in arbitration, appellant before your lordship. No, in this I was the claimant. I stand corrected. Two references.
Please, Mr. Ghosh, as it is, I am confused.
I am more confused. There are two references. Two references. I got more confused. There are two references. I stand corrected. The claimant in the there was an award in my favor. Allegation is the work was not complete. The work relates to work was a turnkey basis for erection of a copper dam, dismantling, removal, repair, supply, and replacement of requisite items.
Mr. Ghosh, allow us 7 minutes just to go through the judgment once. Just take your seat. Yes.
There were two references.
First was before the MSME Council by my learned friends. That's successful. I have suffered an award there. The second reference was, Millard, before the normal arbitral tribunal, Millard. Then I got an award. The Garden Ridge got an award. That has been set aside on the ground, Millard, that Shilpi construction doesn't apply, but it's a composite contract, Millard. It's a work contract. Now, work contract, Millard, there are authorities to such effect, Millard, starting from Coney elevators, Millard, cone elevators, Millard, that Millard, this Millard cannot be covered by Millard under the MSME. It's a composite contract. I'll show you, your lordship. It cannot be covered by the MSME contract. The second argument, which was on the basis of Shilpi, Millard, was that registration of by MSME was Millard afterwards, but Millard supplies were made prior to that, Millard. Supply services, whatever. It's a composite, Millard. It's a turnkey contract. It was done, Millard. So that Millard portion, Millard, though doubted, Millard, I don't say it's been set aside. It has been referred to the larger bench of the two Supreme Court, Millard, referred to their, Millard, in 2024. Millard. So this is the issue, Millard. It's a pure jurisdictional issue which I wish to argue. And the second part, because the award has been set aside only on that ground, because the arbitrator lacked inherent jurisdiction, Millard, because it will be done by the council in question. There are two setting aside applications, Millard, one filed by me, Millard, which is before the Alipur Commercial Court. It's pending. The second one, which was filed by my learned friend Millard in this court, that has been allowed on the jurisdictional ground.
So Marine Craft was the supplier.
Marine Craft was the supplier. The nature of contract, if your lordship Millard takes Millard page 85 and 86, the scope of work at volume 1, page 92.
So are you saying that the jurisdiction of the council,
yes,
the facility council, right?
Facilitation
Council, is not exclusive?
It's not, Millard, exclusive if it's a works contract in question. Secondly, Millard, if there is, with deepest of respect, Millard, the 2024 judgment I'll cite it, Millard. If there is, Millard, a contract, if there is a registration which is, Millard, taken place, Millard, afterwards, before the contract has been entered into, what is the effect in law? Because the entire dispute, Millard, cannot be, Millard, covered by, Millard, the MSME Council, Millard. So this is the point in substance. The learned judge has construed, Millard, on our understanding of the subject, Millard. Millard, we are up in appeal. The second point, Millard, what I find, Millard, under, Millard, section 2(6) of the Commercial Court Act, read with 218, Millard, 21C6 of the Commercial Court Act, read with section 18, read with, Millard, 21C18 of the Commercial Courts Act. This had to be filed in the commercial jurisdiction. Kindly look at it. But it has been heard, hearing done, order passed in the normal jurisdiction. What is the effective law? Under section 15 of the Commercial Courts Act, pending proceedings can be, Millard, transferred. New proceedings can't be done after, Millard, Lakshmi Polyfab's case. This point, Millard, I should be candid, Millard, was not taken by the person and the court below. But it's a point of law I can always argue. Kindly have a look at, Millard, the Commercial Courts Act. Kindly have a look. This will come last, Millard. My main point, Millard, is, Millard, MSA. Kindly have a look at the Commercial Courts Act. Commercial Courts Act. Millard, 2(1)(c), lordship will take, Millard, 6, construction and infrastructure contract, including tenders. So, Millard, this is arising from a tender in question, from a tender process. Section 2(1)(c), lordship will take, Millard, 6. Construction and infrastructure contracts, including tenders. So there was a tender process. It's a construction, Millard, and infrastructure, Millard, contract. Millard, preparing of, Millard, flap gates, Millard, in, Millard, the port in question. And if, Millard, my learned friend says it's a service, then service is covered in 2(1)(c)(80). Agreement for sale of goods or provision for services. So both way, Miller, it cannot be filed because it's above the specified value, Miller.
Services?
Miller, kindly take Miller. Service is 18.
Yes.
21C.
Service 18.
What if something এটা আমি কত দিয়েছি আমারটা বলো ওটা নিয়ে লাফাচ্ছ
Yes.
The awarded sum is Miller 30 lakhs 24,849. So it's within the concurrent Miller limits of the City Civil Court and High Court, and above 10 lakhs Miller we file it Miller commercial division. So that is Miller the first point on jurisdiction. It should have been taken. 1 CR is exclusively High Court. 10 lakhs 1 to Miller 1 crore is Miller within the domain of High Court and City Civil Court both. But City Civil Court Miller, it can be filed here or can be filed there. That is the position in law as on this day. And so far as the state amendment is concerned, state amendments, 30 lakhs and above Miller is the commercial division specified. So both way it's a commercial matter Miller. This is the first point Miller on jurisdiction I take. If your lordship Miller takes section Miller 15 Miller of the Commercial Courts Act regarding Miller, section 15, chapter 5.
Hey. Micro, small and medium.
Copy আছে তোমাকে বসো
15.
1550, chapter 5, transfer of pending suits. Miller, suits arbitration is covered Miller in the section Miller 10 of the act in question. So far as Miller transfer of pending suit, all suits and application, including the application of the Arbitration Conciliation Act 1996 relating to commercial dispute of a specified value pending in a high court where a commercial division has been constituted shall be transferred to the commercial division. So if it's a pending proceedings Miller, it would be Miller transferred to the commercial division Miller in question. Setting aside. It's Miller 80. The commercial division. So Lord, if it is pending Miller as when if we had the commercial court at that point of time, then Miller it can be transferred. Otherwise, it has to file. That is Miller the first point. Now Miller on the merits of the matter.
No, this point was not argued, so it was disposed of. What happens? Is it a nullity?
Miller, I have suffered Miller a judgment on the order was set aside on that ground and on a Miller it was not taken.
Remanded.
It was remanded Miller, set aside and remanded. Miller, it was a Miller on an order by a coordinate bench, order 9 rule 13 Miller. This point was taken Miller and it was remanded. They came forward, the trial court said no, this is not a nullity, it can be done. Now Miller, I show my learned friend and hand up Miller, I don't have the copy. It's a 4th of July 2023. এয়ারড্রপ করে চল মে হ্যান্ড আপ মিলার একবার ওকে দিয়ে দাও না ছেলে এটা আমি দিয়ে দিই এয়ারড্রপ করছি তো এখন দিচ্ছি I was on the receiving end. আমাদের কমার্শিয়াল ডিভিশন কবে সিলেক্ট হয়েছে এতে দেখ না না হলে ট্রান্সফার করেও সেদিন হিয়ারিং হবে ফর্মালিটি করে অসুবিধা কি আছে আমাদের ডিভিশনটা কবে হয়েছে দেখি জাস্ট কটা ফর্ম ফাইল করে 2018-তেই হয়েছে শিওর
কবে হলো আমাদের?
So without proceeding with Miller, there is a difficulty. কবে ফাইল হয়েছে বলুন? The government তো পারেনি, government PSU তো আমি সব দিতে পারতে পারবো। এটুকুনো লিকুইড আমার প্রবলেম হবে ফাইল। Millard, our Millard commercial division has been constituted on 6th of September, 18th of September 2017. This application was filed on 6th of December 2018. So it's after Millard constitution of our commercial courts. So what is the effective law? So for Millard, this judgment is the is concerned, it says Millard, it has to.
In that one, the time to file written statement was extended by the division bench.
And the extended and Millard, the decree which I have got, what status?
This point of whether it's an aliti or
No, that Lordship wants to decide, Lordship will decide, because there is Millard no provision under the Act for Millard transfer of a new proceedings which is wrongly. It can only be done subject to correction. Millard, I have checked up the law in question by invoking Millard section Millard 24 Millard of the or Millard 151 read with Millard section.
Yes, because we are doing that regularly. We are doing that.
Because then Lordship has to go there. So far as this Act is concerned, there is nothing. It's Millard, for Millard, the new proceedings wrongly filed, Millard, its Act is Millard silent, special statute, it's silent. It's not there, Lordship can read it with me, Millard, it's not there at all. Whether Millard, Lordship Millard can invoke Millard 151 to do that.
So relying on section 21C and section 15, what
18,
is it?
18 Millard, 18,
21C 6 and 18.
18.
And section 15 of the
15 of
commercial.
the Act.
What is your submission?
Millard, this Millard, perhaps Millard cannot be transferred to the any other forum. It has to be done again, Millard, with Millard article for section 14 limitation, because the Act doesn't provide so. Millard, Lordship, of course, Millard, Lordship in a can Millard always. That's within the power of the High Court to Millard invoke section 151 to do that. But the Act doesn't contemplate. Like Millard,
Yes, we are conscious of that. The Act doesn't contemplate.
Act doesn't contemplate it. Because Millard, even latest patent appeal has been taken away by the Act in question.
This is your first point then?
Then the second point, Millard, the second point is Millard, it's a composite contract, which is Lordship will find in page Millard 92, volume 1 of Millard, the paper book in question. Kindly look at the work in question, because my second point is a works contract. MSME Council will not have jurisdiction to decide this. This is my second point. Kindly have a look at the scope of work, page 92. This is not merely a service. Kindly have a look at page 92. Dismantling and removal of flap gates, 1. 2. Erection of cofferdam, sheet piling to restrict tile defect, etc. to ensure continuous proper work. The same to be dismantled after completion of the work, wet basin mouth. Then 3. Repair of dismantled structure, if any, including supply of materials. Kindly have a note at that. On completion of required activity, steel surface to be cleaned and 2 cost of situ bitumen solution to be applied. 4. 4. Replacement of damaged salud. Sal's wood section by new Siliguri such and such as per drawing number. Salud section to be supplied as per the specification. 5. Replacement of existing rubber seal by 1 as per specification. 6. Replacement renewal of the entire securing of holding of fasteners, woods, rubber combination gate, etc. etc. Now 7. On completion of repair of the activity of the gate will require installation commissioned and handing over to the dock department of Garden Ridge. 8. To ensure water tightness for minimum 24 months.
Before you proceed, under what head did you claim against the supplier?
Kindly, Millard.
What was the nature of your claim?
Yes, kindly, Millard.
No, just tell us. Just
non-completion of the jobs. Jobs have been left incomplete.
Purchase.
The gate is no. Normal, Millard. I have done it to someone else, Millard. I have risk purchase clause per se was not informed.
My learned friend is not correct. Entire claim is on account of damages for future loss that he might suffer.
Right. Very.
Well, I'll show Millard what is there in this statement. My learned friend will have his chance.
I just said.
Now, factually, you correct me when you get your chance if I am wrong. This is a system which has come up, Millard. You stand up, start arguing. Millard, kindly take, Millard, the award in question. Kindly have a look at the award.
Page.
Millard, kindly take the award. It's the last volume. Volume number 6. Right? Yes. Volume 6. Lordship will kindly take. The issues are at 756. Thereafter I come. Yeah, that's one. 746. These are the issues before the learned tribunal, Millard, itself. First issue is whether the tribunal had jurisdiction.
7.
Millard, kindly take page number 756 of volume 6, Millard. If you take page number 725 to 847.
Issues, yes.
These are the issues. Now findings are at 757. So far as issue number 1, is on the jurisdictions. The section 16 was filed, that was basically dismissed. The issue has already been decided, video order dated 28th of February 2017 as a preliminary issue on the ground of maintainability on the point of jurisdiction of the tribunal. The issue was decided after contesting the hearing of the parties at length. There are certain disputes between the parties regarding execution of the work, a sum of rupees 87 lakhs to the advocate such and such. Now, Millard, kindly take Millard his appointment, Millard. This is Millard as a chairman, managing director. This is Millard before Millard, the amendment in question. Now, Millard, kindly take Millard, page 758, paragraph 20. Both the parties have argued much on limitation at length, argument advanced by the parties on the facts and law, and the issues together for the unnecessary repetition. The claimant has claimed for an award of rupees for incomplete portion. This is Millard finding of the arbitrator. The claimant has claimed an award for incomplete portion of the contractual job. Further award for a sum of rupees such and such on excess payment together with interest. So my claim is on account of incomplete job, not for any future damage. On the other hand, the respondent has a counterclaim of 85 lakhs and odd. The respondent and the claimant had taken the plea of limitation together. Now, my lord, kindly take 759, internal page 12 of the award, page number 23. Admittedly, the claimant, in or about 2010, issued a tender notice from the intending bidders for repairing of the wet basin gate at the main yard in order to stop leakage of water and also dismantling of flap gate. So, my lord, tender and my lord, dismantling lordship finds, my lord, which is a commercial dispute. The notice was issued on such and such. The scope of the work clearly indicated therein. Pursuant to the notice inviting tender, the respondent Marine Craft submitted a bid along with other bidders. The bid of MEPL was accepted with a letter of intent in its favor dated such and such. Now, my lord, kindly take, my lord, para 25. I'll not read the entire award, my lord, only, my lord, few places. It is alleged that the bottom blast tanks were not repaired or not even attended to. The wet basin flap gate could not be made watertight and leakage water was discovered within a short while. The case of the respondent is that repairing of the bottom blast tank was outside the scope entrusted to it, but this plea of the respondent is not at all correct. The letter of intent dated such and such describes the scope of the work in which the above work is specifically mentioned along with the contract, so the respondent cannot deny the work entrusted to it. In support of the respective cases, the claimant examined on Arun Kumar Mohapatra, additional general manager of the claimant. He had sworn an affidavit in evidence. The conversely, Mr. K.K. Shah, deputy general manager of MEPL, has sworn an affidavit of evidence as RW1. He is examined, cross-examined in details from both the evidence of CW1 and RW1 as well as from the documents like notice inviting tender, the letter of intent and the purchase order. It is very much clear that dismantling and removal of flap gate, erection and cofferdam and mantling of the same after completion of other works were entrusted upon the respondent. The respondent cannot deny these things. There are various correspondence from Garden Reach which are brought into the evidence as exhibit number such and such from the From the documents, I am bound to hold that the work was not completed. It is clear from correspondence dated 19 June 2013, Exhibit JJ, that Mr. Arunpal Bhattacharya, manager, requested MEPL to complete the job latest by 15/7/2013. Thereafter, no correspondence is there on record by MEPL regarding completion of work. 7 except email dated 30th July 2023. On the blank order done certificate, KK was sent to MEPL to Garden Reach requesting signing. The email dated 37/20 issued by the respondent for the work done proves that based on 37/2013, the work was completed by MEPL, although actually not done. Before this mail, there was no approach for joint inspection of the work done. There is no cogent evidence on record that the work was completely done by MEPL. In order to establish the claim, engaged government registered valuer to assess the expense incurred to complete the leftover job by the respondent. The report has been submitted, wherefrom it appears a sum of rupees 19,1916,889 were required to be completed, required for a wash basin, but the claimant has claimed only rupees 27 such and such. Now, the claim below the estimated cost expressed by the expert cannot lead the tribunal throughout of the entire case of the claimant. Since it's a turnkey project, the project respondent cannot deny its obligation to repair every part of the wet basin flap gate. From the above discussion, it is clear that the respondent has left the contractual job incomplete, so it is bound to pay the required job. In paragraphs number 59 and 60 of the statement of claim, there is a specific claim for return of excess payment to the tune of such and such. This has been established by several documentary evidence which are not refuted by the respondent. Therefore, I have the opinion they are also overpayment of rupees 2 lakhs which must be returned. The claimant is thus found to be entitled. If the version of the respondent that the work was completed on or before 37/2013 was correct, then of course the limitation will be counted from that. But from the tender notice as well as from the purchase order, it is very much clear that defect liability period for ensuring water tightness shall be 24 months from the date of completion of certificate issued by the berth. If that be so, starting point of limitation will shift from 24 months from 37/2013, that would be 37/2015. On prayer of the claimant, sole arbitrator has been appointed on 22/8/2018. It's obviously within 3 years, and as such, there's no question of limitation in view of over 30 lakhs. So this is the case. Now, jurisdictional order, Lordship will find at page 303, annexure S. 303 Annexure S, Volume 3, which Millard starts from 291 to 440.
These are the minutes.
Millard, this is Millard the section 16 order. Order or other proceedings? Nature of minutes, Lordship can say. Because he has referred Millard to this order, Millard, in the final order, Millard, allowing Millard the claim. Now, Millard, jurisdiction, I'm not reading it, Millard. 304 Millard, bottom Millard, is Millard the disputes regarding Millard application filed Millard by Millard by learned friend before the Millard council in question. Then Millard 305 Millard various orders Millard why it should either it should go to the council or the arbitrator Millard these judgments were Millard relied upon. Then decisions with reasons is 306. MEPL as a petitioner filed WP number such and such in the Honorable High Court at Calcutta, which decided video order dated 19th of September 2016. In the aforesaid writ petition, both the parties submitted their contention as stated above. Considering the submission, High Court has pleased to opine. In the considered view of the bench, writ petition has been rendered infructuous to be by the reasons of the counsel being appointed by the petitioner during its pendency. It shall be open to the petitioner to seek relief before the council in accordance with law. If at all the respondent has any claim against the petitioner, it shall be also entitled to proceed in accordance with law for recovery of the amount due and payable by the writ petitioner. So writ court says, Millard, you have two references, you both proceed in accordance with law. Millard, so Garden Ridge goes before Millard in normal arbitration under the Act. Learned friend goes Millard before the MSME council. In the aforesaid writ petition, MEPL was the petitioner and Garden Ridge was the respondent. Now, Millard, kindly look at the finding. From clause 18 of the purchase order, it is clear that any unsettled claim, the question of dispute arising between the parties shall be referred to the chairman and managing director of Garden Ridge for adjudication of the said arbitrator differences in accordance with the Arbitration Conciliation Act. The arbitrator, as per section 16 of the Arbitration Conciliation Act, has power to decide the claim and counterclaim, but the council has only power to decide the disputed claim and not the counterclaim. From the facts and decision clear above, it is crystal clear the disputes, a claim and counterclaim can only be decided by the arbitral tribunal. The facility council is not even to give a full relief to the counterclaim. There is no room for adjudication. It is well settled principle of law that all the disputes should be adjudicated together. No dispute should be left for decision in a separate proceedings. The arbitral tribunal holds a jurisdiction to adjudicate the disputes between the parties and fully, completely, while the council has no such jurisdiction. During the argument, it is submitted on behalf of the respondent that no claim can be submitted till the date of the argument. From the material on record, it is seen the respondent has not yet submitted its counterclaim before this tribunal. After that, without prejudice, they are submitted. It has made claim before the facilitating council. In the meantime, one statement of claim on 22nd of February 2017 with the copy of documents claimant through suit post. Copy of the same has been sent by a letter dated such in such circumstances fixed on hearing for taking over the subject copy. Order 16 and order. Millard, I just come back to the order once, Millard. So this is Millard what he holds, Millard. You file your counter claim and I'll decide the issue. Order. So Millard, today's main point, Millard, what I wish to argue before your lordship, Millard, whether Millard the council, Millard, on itself, Millard, can Millard take up the entire Millard the contract itself, which is a work contract, a turnkey contract, and Millard disposed of the reference, Millard, in accordance, my lord, with the MSME Act in question. So, my lord, this is, my lord, where we stand. We had already filed, my lord, the earlier bench was of the view, my lord, that we should file our short notes. We have done that, my lord. All the judgments are there, my lord. We have done so.
Very short.
So judgments, my lord, judgments are there. My lord. Judgments we have to give. My lord, the Kone elevators is going into so many pages because he felt, my lord, the judgment should be there with the notice. Section 16.
Yes.
But section 16 and all that. Faltu patavarta karo. My lord, kindly takes, my lord, now the order impugned once, page 818. This is what we challenge. I gave the notes because it will be shorter for me because points are all there. The petitioners, my lord, kindly take 818. Lordship has read it. Lordship will kindly take, my lord, para 2. ঠিক আছে দেখে নাও আরেকবার ভুলভাল হলো ওর রেফারেন্সটা কবে আমার ওর কবে শুরু হয়েছে আমার দুটো ডেট লিখে দাও আমারটা বোধ হয় ঠিক আছে ছেড়ে দাও তো কখন ধরবে বলে কি দাও এখানে মামলা করছে আমাকে বলোই বা কেন
Yes. Please refer to the internal page numbers.
very well definitely well at internal page 2 minute মেমো অফ অ্যাপিলটা দেয়নি না আমার কাছে আছে আলাদা করে অর্ডারটা বার করে The petitioner is registered micro and small scale enterprise was and was the respondent in arbitration before the sole arbitrator. The petitioner is a supplier of services and respondent is the buyer in dispute before the arbitrator. The contract related to repair of a wet basin flap gate at Garden Ridge Shipyard. Millard, kindly me look at Millard. Kindly take this Millard. Naturally, Millard, the things went. Let's read this with Millard, page 92. It's not repair. It's Millard dismantling, repair, supply, and Millard. Thereafter, after that, everything has been done. He has to do Millard the defect liability. This is page 92. So it's only not for only repair. The petitioner made a reference on 11/5/2016 under the provision of the Micro, Small, Medium Development Act 2006 before the West Bengal Facilitation Council, and the respondent was called upon to appear before the Facilitation Council on 4/7/2016. During the pendency of the reference between the Facilitation Council, the respondent appointed an arbitrator on 23/9/2016 on the basis of the clause of the purchase order. That Millard provides. The arbitrator issued a notice to the party on 4/10/2016 for adjudication of the disputes arising out of the purchase order. The petitioner thereafter challenged the jurisdiction of the arbitrator under section 16 of the arbitration, which was rejected on 28/2/2017. The facilitating in the meantime in its meeting on 27th by way of a notice issued to the party on such and such. The petitioner also filed a writ petition in the High Court inter alia direction of the facilitating to dispose of the reference initiated by the petitioner on 11/5/2016 and restraining the respondents from giving any effect to the invocation of clause 18 of the purchase order. So this was sought for that you do not go forward with your reference in question. This is the Honorable Judge's recording. By an order dated 19/4/2017, High Court directed the counsel to proceed with the reference and dispose of the claim in accordance with law. The arbitrator proceeded to pass an impugned award dated 23/9/2018, whereby which is presently under challenge. The issue which falls squarely for adjudication is whether the arbitrator has the jurisdiction to pass the impugned award. The petitioner questions the jurisdiction of the arbitrator on the ground that the Facilitation Council has exclusive jurisdiction to decide on the reference made by the petitioner in terms of the MSME Act 2006. The learned counsel appearing for the petitioner relies on the fact of the reference of a non-obstante clause contained in Section 18 of the MSME Act. The counsel submits reference made by the petitioner before the counsel culminated into an award in petitioner's favor on 28/2017. The counsel submits the respondent have avoided appearing before the counsel and has sought to invoke the contractual arbitration by a letter dated 22/8/2016 as a counterblast to the reference of the Facilitation Council. The counsel submits the petitioner was compelled to continue with the arbitration in view of Section 16(5) of the Act culminating in the award. The petitioner is entitled to challenge the award. So this is the case. Now, my lord, the learned counsel appearing for the respondent, on the other hand, submits there was no impediment on the learned sole arbitrator entertaining and deciding the dispute. The counsel submits that the disputes to refer could not have been adjudicated by Facilitation Council since it was not dispute contemplated under Section 17 of 18 of the 2006 Act. The counsel submits the petitioner's supply and respondent's buyer as defined under the in terms of the work order issued to the respondent for executing the repair at the gate main on a turnkey basis. So it's not a mere millard, basically millard services millard or millard a supply in question. You have to millard deliver goods also. And the contract was on a turnkey basis. Definition of supplier worker relation. You see them, yes. মুখে লেখা আছে।
Yes, Mr. Ghosh.
Counsel submits a letter of intent was issued by the respondent upon the petitioner on 27/9/2012, followed by a purchase order on 6/11/2012. According to the counsel, both these documents constitutes contract and pursuant to which the petitioner rendered its service. The counsel submits the petitioner was registered on MSME on 19/4/2013. So it's admittedly afterwards. Now the line Millard, Shilpi and two other Millard, it has been doubted and the matter is sent Millard to the special bench Millard. Now Millard, there is no decision on this. It's a coordinate bench commenting on a coordinate bench Millard and sending it Millard. This is the position of law as on this statement. I'm carrying it Millard, I'll cite that Millard. Which would mean the contract between the parties was entered prior to registration of the MSME under the 2006 Act. So Millard, whether Millard the contract could go. The controversy in the present matter centers on whether the Facilitation Council under the Micro, Small, Medium Enterprise Development Act would have an exclusive jurisdiction to entertain and decide the disputes before it by the petitioner. The petitioner claims to be a supplier defined under 2N of the 2006 Act. Section 2N envisages supplier to file a memorandum with the authority under Section 8.1 of the Act where the procedure is outlined. The authority under Section 8.1 may be specified by the state government under Section 8.4 in case of micro, small enterprise, or the central government under 8.3 medium enterprise. The first assessment would be to whether the petitioner qualifies as a supplier under the Act. The answer to the question would turn whether the petitioner could approach the council for making a reference to micro, small enterprise under Section 18 of the Act for recovery of the amount due to the petition under Section 17 of the Act. So, Millard, if you want to make this adjudication, Millard, the nature of contract has to be seen, Millard, and it has to be read with Section 2N, Millard, for the purpose of sending you to the altogether to the MSME Council. According to the respondent, the petitioner is not a supplier under 2N since the contract was executed between the parties before the petitioner was registered on MSME. The petitioner contends otherwise. The petitioner says the relevant date for the respondent buyer to make payment falls on or before the date agreed upon by the buyer and supplier under Section 15 of the Act. According to the petitioner, the liability of the buyer to make payment does not relate to the LOI or purchase order, but on the date when the petitioner completed the service and raised the bill to the work which is subsequent to the date of registration of MSME. On the factual score, the petitioner was registered under MSME on 13/4/2013. The work was completed in July 2013 and the work certificate was prepared and made over to the petitioner.
Mr. Ghosh,
yes,
there's another bench and the learned judges have arrived.
I'm very sorry.
No,
I did not
no,
notice
no,
it.
no.
I'm very sorry.
That's all right. So when?
Wednesday.
After recess?
If it is on Wednesday, Millard, I'll not lose few matters. That's all. If Lordship keeps it on Wednesday as the first matter, I'll finish it off. It will give me, Millard, not Millard anything. I leave it to you. I leave it to you. Lordship once, I'll do it after.
First matter করা আছে তো।
Yes. Wednesday, Millard, it's a
You are in difficulty.
little bit of difficulty. If Lordship says division bench, I have to be
The
here.
problem is that, continuity.
Very well, I'll be here. I'll be here.
At
I'll be
2 o'clock?
Yes, I'll be here.
If you can finish it off better.
Yes, I'll be here. Lordship says I have to be here.
দুটোর সময় হোক।
তোমার অসুবিধা থাকলে বলো, নেই তো? If it could be very well. So I first appear 2 o'clock. হ্যাঁ, তুমি করে দিও।
No, if you are highly inconvenienced.
Not a highly, it's not a question. My senior told me it's a division bench. You have to be before the division bench.
for appropriate direction. Chala.
I'm grateful, my lords.
Millard. I'll cite the judgments. There's no page number, so I've told them to flag mark.
আমি এটা বলি না
আমার দুজন মিলে বলো।
হ্যাঁ continue.
ঠিক আছে? Millard, I stopped Millard after the council's submission. Now Millard Lordship has to take internal page 4, running page 821, para 10 Millard of the impugned award, impugned order Millard.
Yes.
The controversy in the present matter centers on whether the Facilitation Council under the Micro, Small, Medium Enterprise 2006 would have exclusive jurisdiction to entertain the disputes, decide the disputes brought before it by the petitioner. The petitioner claims to be a supplier within Section 2N of the 2006 Act. Section 2N envisages the supplier to file a memorandum with the authority under Section 8.1 of the Act, where the procedure is outlined. The authority under Section 8.1 of the Act specified by the state government under Section 8.4, and in case of micro small enterprise or the central government under Section 8.3 of the Act. The first assessment is whether the petitioner qualifies as a supplier under the Act. The answer to this question would turn to decide whether the petitioner could approach the council for making a reference to micro small enterprise and under Section 18 of the Act for recovery of the amount due to the petitioner under Section 17 of the Act. Let people go there because the interest component is much more. It's 21% and all Millard take it. In normal Millard, arbitration is Millard PLR plus 2%. That is Millard the case. That is Millard the fight all about. According to the respondent, the petitioner is not a supplier under Section 2N of the Act since the contract was executed between the parties before the petitioner was registered on MSME on 19/4/2013. The petitioner contends otherwise. The petitioner says the relevant date for the respondent buyer to make payment falls on or before the date agreed upon between the buyer and the supplier under Section 15 of the Act. According to the petitioner, the liability of the buyer to make payment does not relate to the letter of intent or the purchase order, but on the date when the petitioner completed the services, raised the bill pursuant to the work done, which was subsequent to the date of registration of MSME. On the factual score, the petitioner was registered under MSME on 19/4/2013. The work was completed in the middle of July 2013, and the work done certificate was prepared and made over to the petitioner by the respondent by letter date 30/7/2013. The petitioner referred the dispute to the Facilitation Council in relation to the demand made by a letter on 27/1/2016, which referred to bills dated 2/2/2015 with effect from 30/7/2013 for rupees 54 lakhs, as well as further amounts for 15 lakhs, which were released after the defect liability period, which ended in July 2013. Hence, the petitioner's demand for payment was made with reference to the work and services by the petitioner under which the petitioner's registration was 19/4/2013. Section 15 of the MSME Act cast an obligation on the buyer to make payment of supplies of goods or services rendered by the supplier on or before the date agreed between the buyer and the supplier. Section 15 indicates the buyer's liability to make payment to the supplier essentially arises from supply of goods or rendering services and receiving such by the buyer on or before the agreed upon between the buyer and the supplier. The payment is also to be made before the appointed date as defined under 2B, meaning the day following immediately after expiry of 15 days from the date of acceptance or the day deemed to be the acceptance of goods or service by a buyer from the supplier. Explanation such and such clarifies the day. There is no dispute that the present case the petitioner completed the services in July 2013, raised bill subsequent thereto starting from 20th February 2015 with effect from 30th July 2013 for various amounts outstanding to the petitioner as on the date of the demand letter dated 27/1/2016. The decision of the Supreme Court, this is Millard what, in Shanti Conductors Private Limited versus State of Assam was rendered on the interest on delayed payments scale ancillary industry, which was the predecessor of micro, small scale, medium enterprises. Supreme Court construed Section 3 and 4 of the Act which is parameter with section 15 and 16 of the MSME Act. Shanti Construction held the liability of the buyer to make payment of interest shall arise if the suppliers were made subsequent to the enforcement of the Act, even if the agreement is entered prior to the enforcement of the Act. Para 62 and 68 of the report specifically record that the Supreme Court agreed with the argument of the appellants and held that even if the agreement for sale is entered prior to the enforcement of the 1993 Act, the liability to make payment under Section 3 and to pay interest under Section 4 shall arise if the suppliers are made subsequent to the enforcement of the Act. It is further observed the liability in this case did not relate to any event to take place by the 1993 Act. The later decision of the Supreme Court in Shilpi Industries versus Kerala Road Transport reported in such and such applied the ratio of Shanti conductors and held that even if there is an agreement between the parties for resolution of disputes to arbitration, the seller can certainly approach the competent authority if the seller is covered under the 2006 Acts for making the claim. The Supreme Court held that being a special statute, MSME Act will have a overriding effect vis-a-vis the Arbitration Act. The Supreme Court referred to Shanti Conductors, paragraph 26 of the report, and held that the appellant before the Supreme Court was not entitled to seek benefit of MSME Act, and there was no material to show that the supply has taken place or services were rendered subsequent to registration of the appellant under the MSME Act. The finding of the Supreme Court is thus distinguishable from the facts of the case. Here the claims of the relates to a subsequent event to 19/4/2013 and the date which was registered as micro interest. This is contrary to subject to correction 42 para 44 of Shilpi Industry, which I will place. The learned counsel for the respondent also relied on a recent judgment of the Supreme Court in the Gujarat State Civil versus Mahakali Foods on the same proposition. Paragraph 33 and 34(6) of the relate to the ratio of Shanti Conductors and Shilpa Industry, and the point above, Supreme Court held that if party obtains a registration subsequent to the execution of the contract, the provision of would apply to the supply of goods and service subsequent to the registration. Neither Shilpi nor Gujarat Civil Supplies Corporation assists the respondents for denuding the Facilitation Council for entertaining the petitioner's reference under the provision of the MSME Act on the ground the petitioner was not a supplier at the time of execution of the contract between the parties. To contextualize the fact, the petitioner referred the disputes to the Facilitation Council by a demand letter dated 27/1/2016, which specifically refers to the bill dated 20th February 2015 with effect from 30/7/2013. Since the defect liability period expired in July 2013, the services for which the payment was demanded were rendered by the petitioner subsequent to 19/4/2013 when the petitioner obtained registration and ended on 30/7/2013 on the date of communication of the final completion certificate to the respondent. The letter issued on 27/2013 by the respondent would show that all the activities were scheduled to be performed by the petitioner after 19/4/2013. This unmistakable conclusion that Gujarat State Civil Services, Shilpi Industries, from most recent is the petitioner has a right as a supplier under MSME Act to approach the filing for claiming of the recovery of dues from the respondents. To answer to the second issue, decided in favor of the petitioner, Facility Council has exclusive jurisdiction to disputes brought between the petitioner decide on the Section 18 under the Act. Under Section 18, Council also entered to take up the dispute for arbitration. The provision of the arbitration shall automatically kick in and apply to the dispute as if the arbitration was in pursuance to the arbitration agreement under Section 7(1) of the 1996 Act. In light of the above discussion, internal page 10, in light of the above discussion, the conclusion of this court is as follows. The date of execution of a contract between this buyer and a supplier under the MSME Act is irrelevant for an application for the provision of the MSME Act, provided the supply claims recovery of the amount due under Section 17 of the goods supplied or services rendered after the date of registration. In other words, whether supplier was registered as an MSME on the date of the contract would not disqualify the supplier from making a reference to the micro small enterprises of Facility Council under Section 18 of the recovery amount, so long as the amounts claims are relatable to the goods or services rendered after the date of registration of the supplier as a micro, small scale or medium enterprise under Section 18(1) of the Act. If the supplier fulfills the aforesaid conditions and make a reference to the Council under 18 of Council steps in as the only exclusive forum to decide the reference under the MSME Act. The exclusivity of the jurisdiction of the facility to decide the reference clearly spells out Section 18, including non-obstante clause, which is a precursor to subsection. Well, that is quoted. The non-obstante clause is quoted. Now, Milord, kindly takes the next page, Milord. Section 18.2 confers the council seamless power to take up any dispute in form of conciliation, thereafter arbitration under 18.3 of the Act upon failure of conciliation. Under 18.3 of the provision of the Arbitration Act spring to life and disputes assume the character of a trappings of an arbitration. Consequent upon an arbitration agreement under Section 7.1 of the 1996 Act, the exclusivity of the jurisdiction of the facilitating council is the most categoric declaration under 18.4, which also starts with a non-obstante clause, specifies the facilitating council shall have the jurisdiction to act as an arbitrator under Section 18.4 in a dispute between the supplier located within the jurisdiction. To return to the present dispute, the unilateral act of the respondent in invoking the contractual arbitration clause and appointing the learned sole arbitrator on 23/9/2016 after the petitioner has made a reference to this is patently contrary provision to the MSME Act. Lordship will keep in mind there was a writ petition. A prayer was sought for restraining the appellant before your lordship from invoking the clause. That was not granted in the writ petition itself. That order, my lord, I had placed, my lord, before your lordship. Moreover, the respondent invoked the clause and proceeded and made it before the arbitrator appointed is fully aware of the reference of the facilitating under the MSME Act was pending as on the date. The impugned award dated such and such with a claim of rupees 30 lakhs was allowed in full, hence in form of the face-off with the provision to speak, and the award was set aside in view of the ratio of Millard according to the Honorable Judge Shilpi. This is Millard 3 points. First point, Millard, I'll point out from Shilpi Industries, Millard, this is what not Shilpi Industry has said, Millard, in no unequivocal, or no, Millard, that Gujarat, Millard, Mohakali, Millard. Second point, Millard, is a more, Millard, point in the though, Millard, I am carrying the judgment that Shilpi's, that 3 findings, Supreme Court felt this is the finding of Shilpi. But Supreme Court, Millard, these are all 2 benches, Millard. The third 2 bench judgment, Millard, which is 2025, Millard, felt, Millard, yes, they have said so. We are not agreeing with the proposition, but as a coordinate bench, we cannot do anything to that. So we refer it to we are doubting Shilpi, but we are referring it to the larger bench. What is the legal effect, Millard? I, as a counsel, Millard, have my doubt. I mean, also in Millard, little Millard, in desire, Millard, what is the legal effect? Two benches on one side, 1 bench is on the other side. The last bench refers, Millard, the earlier.
The Supreme Court itself has said the earlier will prevail, so long as it is not upheld by a larger bench.
There is a problem, Millard, in a matter, Millard, under the Millard Public Premises Act, Millard, the earlier view was taken into consideration. Supreme Court says this is our recent view, why the High Court didn't follow it. And also, Millard, in the OTS scheme, Millard, this has been said, Millard. This is our latest view, why the High Court followed the earlier view. In the OTS matters, Millard.
Same strength bench.
Same strength bench, Millard. This is it. But so far, my knowledge, we have learned from the colleges, Millard, that, Millard, it's the earlier view is always prevail. But in the OTS is more specific, because recently I'm coming out of a matter in one of the order has been set aside by the High Court of Haryana, Punjab and Haryana, saying, Millard, why our present view has not been followed. I think I'm correct on that. So, Millard, this is the view on the subject. The second most important point, Millard, which I want to, it's a legal point. It's a turnkey contract. A nature of a works contract. Purpose of the works contract is for the purpose of taxes. Now, Millard, if it's a works contract, there are services, supply of goods, construction, erection, dismantling. Whether, Millard, it will fall under the claim, one can, Millard, take, Millard, the shelter of Section 2N and get it in MSME Council. Because it's a all-comprehensive turnkey contract which they will award, Millard, records. That's page 95. That's page number, if your lordship takes page 92 of your lordship's briefs. It's an all-comprehensive contract, not a mere, Millard, offering services or, Millard, supply of goods. Millard, kindly look at this situation today, Millard. There was an injunction, Millard, which was sought for restrain, Millard, the appellant herein from invoking clause 18 of the contract that was not permissible. So both parties goes, Millard, to 2 different forums. They fight out. Milord, one award, Milord, I represented that I am not coming to. It has been passed against me. I challenged in Milord before the honorable commercial court, Milord, because Garden Rich, Milord, has the jurisdictional clause there, Milord. So I challenged it. My challenge was unsuccessful. In section 34, Milord, it was unsuccessful. And on an appeal, the award was set aside and remanded before the court again for deciding the section 34. That's pending.
Remanded to the council.
To remanding it, Milord, to Milord, the first court to take up the section 34 again. Because the then division bench felt there are no reasons because their main
award was not set aside.
No, award was Milord, what the award was not set aside, Milord. The council
34
awards,
order was set aside.
34 order was set aside. So today the situation is, Milord, that so far as the respondent is concerned, Milord, he has an award that the work has been done for them by the council, whatever be the award. The award which, Milord, the respondent has got, Milord, has been set aside on the jurisdictional error. Now, Milord, today, the reference, I say reference A of my learner, reference A before council has culminated into an award. Reference B before the arbitrator under section 7 read with section 11, Milord, of the act, Milord, has, Milord, resulted in an award, but that has been set aside. So I today cannot go back to the council again. Lordship kindly appreciates the practical difficulty, Milord, of the matter in question. There were two awards, one in favor of the respondent, one in favor of the appellant. The appellant's award has been set aside, the respondent award, Milord,
In any event, would you be able to go to the council?
Milord, this is a little bit, Milord, there is, Milord, after there's an amendment, one can file, cannot file, there are, Milord, debatable issues.
No, we are not on counterclaim. Can you be a claimant before the council?
I cannot be a claimant before the council. I cannot be the claimant before the council. I cannot. I can, Milord, I have a remedy in law to proceed, Milord, before the normal arbitral forum in terms of the contract between the parties. The arbitration clause is, Milord, clause 80. Milord, may I, Milord? ওটা হয়ে গেছে, কমপ্লিট করেছো, জজ সাহেবের কপি করে দিয়েছো, আমারটা করো, কোথায় দেখবো কি করে এটা Milord, let us, Milord. So, Milord, the works contract is one of the issues, Milord. Lordship has to decide whether, if it's a works contract, whether council will have any jurisdiction at all to decide. This maybe in my reference, Milord, will be necessary. Here, Milord, I cannot be the claimant, Milord. This is, Milord. Kindly have a look at page 8 of the show. And ABC. All, Milord, I am not citing, Milord. It was a comprehensive note because of keeping of both the matters before the division bench, because both were pending at that point of time. Kindly have a look at, Milord, tab C, flag C, Milord. After flag বললে পারতো তো আমি কিটা খুঁজে পাবো কি করে গুজরাট স্টেট পেজ দাও সিটা দাও আমাকে একটা স্টিকার দাও সি লিখে দাও আমি লাগাই Milord, kindly take, Milord, flag C, Milord. Now, flag C. It's, Milord, Gujarat State Civil Service versus Mahakali Foods, 2023 6 SCC 401. তুমি আমারটা কেন লাগালে না? Kindly have a look at paragraph 49, Milord. 49. Page 8, tab C. Kindly have a look at page 49. Okay, I am no better.
Page 49.
Para 49, Milord, of Gujarat, Milord. It's internal page. On the top, it's written, Milord, page 39. Flag C, Milord. It was not paginated. I'll do it, Milord. I've just flag marked. Kindly take paragraph 49. One of the submission made by the learned counsel for the buyer that if a party supplier was not a supplier, within the meaning of section 2N of the MSME Act 2006 on the date of the contract entered between the parties, it could not have made reference to the Micro Small Scale Enterprise Council under 18(1) of the Act, and in such cases, Council would not have the jurisdiction to decide the dispute as an arbitrator. At this junction, it is very pertinent observation made by this court in Shilpi Industries on the issue is required to be produced. So Shilpi is quoted, Miller. I think it's better quoting from here. In our view, to speak the benefit of the provision under the MSME Act, the seller should have been registered under the provision of the Act as on date of the entering into the contract. In any event, for the suppliers pursuant to the contract made before the registration of the unit under the provision of the MSME Act, no benefit can be sought by the such entity as contemplated under the MSME Act. No uncertain terms, Willard, it's saying so. While interpreting the provision of interest on delayed payment to small scale and ancillary industries undertaking 1993, this court in the judgment of Shanti Conductors and Assam SEB has held that supply of goods services can be taken as a relevant date as opposed to the date when which the contract of supply was entered for the aforesaid act. Even applying the said ratio, and the appellant is not entitled to seek the benefit of the Act by taking recourse to filing a memorandum under section 8(1) of the Act. The subsequent entering into contract for supply, one cannot assume legal status being classified as an MSME as an enterprise to claim benefit of the retrospectively from the date which the appellant entered into the contract with the respondent. So, Miller, these three lines in the middle, Miller, with deepest of respect, Miller, the Honorable Single Judge has taken without ignoring the full Miller paragraph 42 and Miller the last portion, Miller, of Miller paragraph 43. Now, Miller, the appellant cannot become, paragraph 44 is also, the appellant cannot become micro, small scale enterprise or supplier to claim benefits within the meaning of the MSME Act by submitting a memorandum to obtain registration subsequent to entering into the contract and supply of goods and services. If any registration is obtained, the same will be prospective and the supplies for goods and services subsequent to the registration part cannot operate retrospectively. Any other interpretation of the provision would lead to absurdity and confer unwanted benefit in the favor of the party not intended by the legislation. Now kindly have a look at paragraph 51. Following the aforesaid ratio, it is held that the party who is not a supplier as per 2N of the 2006 Act as on the date of entering into the contract would not seek benefit as a supplier under the 2006 Act. A party cannot become a micro or small scale enterprise or supplier to claim benefit under the MSME Act by submitting a memorandum to obtain registration subsequent to entering into a contract and supply of goods or rendering services. If any registration is obtained subsequently, the same would have the effect prospectively and would apply to the supply of goods rendered subsequent to registration. This one line here she has also taken, Miller. The same cannot operate retrospectively. However, such issue being jurisdictional issue, if raised, could be decided by the Facility Council acting as a tribunal under the MSME Act. Now, Miller kindly takes Miller 52.3. The Facilitation Council, which has initiated the council under 18(2), would be entitled to act despite as an arbitrator. Rest are, Miller, I don't think, Miller, they are so much of relevant on Miller MSME Act. 52.6 is the only one thing, Miller, I real. A party who was not a supplier, as per the definition contained in section 2N of the MSME Act 2006, on the date of entering into the contract, cannot seek benefit as a supplier under the MSME Act. If registration is obtained subsequently, same would have an effect respectively and would apply to the supply of goods rendering subsequent to the registration. This is what, Miller, it has said. So, Miller, this, Miller, would apply to supply of goods after subsequent to registration, Miller, cannot be read into isolation because it's and. And any event, I, Miller, could not have gone to the council. I am a PSU. Now, Miller, this is Miller. Shilpi is quoted, Miller, in this, Miller. I am not referring Shilpi, Miller, individually again. The paragraphs which I want to cite from Shilpi, it's also there, Miller, 42, 43, 44. It's part of this judgment. Now, Miller, on the works contract, Miller, kindly have a look at Miller does tab email. If your lordship takes tab E, Kone Elevators versus State of Tamil Nadu, 2014 7 SCC page 1. তা তো দেবে ভাই, আমি কি অন্যায়টা করলাম? ফোনে নেই, থাকলে এখান থেকে kindly have a look at paras 44, 45 and 46. It's a very big judgment, Millard. It's a ছজন না পাঁচজন, five, Millard, five bench, Millard, the constitutional bench. Paragraph 44, if your lordship takes, Millard. That's internal page 40, Millard. In the bottom, it's written 32. 40 is on the top. On the basis of aforesaid elucidation, it has been deducted that a transfer of property in goods under 29A Article 366 is deemed to be a sale involved in the execution of a works contract by a person making transfer, the purchase of these goods by a person to whom such transfer is made. One thing is significant to note that in Larsen and Toubro it has been stated that after the constitutional amendment, the narrow meaning given to works contract in Gannon Dunkley is no longer survives. It has been observed in the said case, Millard, the quotation is there, even if in a contract, besides obligation to supply goods and materials and performance of labor and services, some additional obligations are imposed, such contract does not cease to be a works contract for additional obligation in the contract would not alter the nature of the contract so long the contract provides for a contract of work satisfied with the primary description of the works contract. Once the characteristic elements of the work contract are satisfied in a contract, then irrespective of additional obligations, such contract would be covered by the term works contract because nothing in section articles 366 29A-B limits the term of one contract, works contract for labor and services only. In the case, another significant aspect has been declared. This dominant nature, we think, apt to reduce below what has been stated in Larsen and Toubro. My lord, Larsen and Toubro is noted. Whether the contract involved dominant intention for the transfer of property in goods, in our view, is not at all material. It is not necessary to ascertain what is the dominant intention of the contract. Even if the dominant intention of the contract is not to transfer the property of good, rather it is rendering of a service or ultimate transaction is transfer of immovable property, then it is also open to the state to levy taxes on the materials used in the contract, if otherwise as the elements of the works contract. Lordship will now kindly take Millard, paragraph 46. At this juncture, it is cordoning to state the four concepts that have clearly emerged. A, the works contract is an individual contract, but by legal fiction divided into two parts, one for sale of goods and other for supply of labor and services. So Lordship has to see page number 92. The concept of dominant test, or for that matter, the degree of intention test or overwhelming component test for treating the contract as a work contract is not applicable. The term work contract, as used in clause 29 capital A of article 360 Constitution, takes into sweep all genera of work contracts, and it should not be narrowly construed to cover up one species of contract to provide labor and services alone. 4. Once the characteristics of a works contract are met with the contract entered into between the parties, any additional obligation incorporated contract would not change the nature of the character. Having noted the conceptual telescopic area and the term once quoted and the principles we have stated here now, it is necessary to refer to the following installation. Millard, now Millard, it's quoted. That's not necessary for us, Millard. Millard, this was cited in a MSME case, Millard. Before Millard, F done. That was division bench done. This was Millard cited in the Allahabad division bench. That is Millard, tab F. Rahul Singh versus Union of India, 2017 SCC online, Allahabad, division bench, 3579 division bench. Millard, this judgment I'll just place few paragraphs. Millard, this was a MSME case in question. Millard, I first place paragraph 2, 3, and 4 with. Two writ petitions question the action of North Central Railway, whereby the tender submitted by the petitioner has come to be rejected on the ground of failure on the part of the petitioner to deposit tender cost as well as earnest money. The claim of the petitioner was that since it was a micro small enterprise MSME covered by the provision of the Micro Small MSME Development Act, it was entitled to the benefits covered by the public procurement systems, which exempts MSME from paying tender cost or depositing earnest money. The stand taken by the respondent is that the tenderers themselves were invited for a works contract, which per se operating manual for North Central Railway did not qualify for the contract for supply of goods and services. Therefore, the petitioner is not entitled to benefit of the public procurement system. The petitioner and which in fact is not disputed by the respondent is a MSME registered with the National Small Industries Corporation NSIC for participation of the central government store program and also for undertaking of civil construction. The eligibility limits conferred upon the petitioner by NSIC, the aforementioned two works is set at rupees such and such respectively. It is stated to have applied for the award contract for the North Central Railway under tender number 45 and 48. The tenders for the aforementioned contract have been rejected for the ground noted. Now, Mr. Such and such a learned senior counsel appearing in support of the petition has contended that both section 11 of the 2006 Act as well as the public procurement policy 2012 formulated by the Ministry of Railways and published on 5th July 2012 made no distinction between supply of goods and services. He therefore contended that rejection of the tender on the ground that it was a work contract was unsustainable. Mr. Nandan first for the concurrent stand taken by the respondent that supply of goods made only to a particular department would qualify for benefits under public procurement is unsustainable in light of the provision of the circular dated 23rd September 20. Mr. Nandan submitted that since the petitioner was a MSME duly registered with NSIC, it was clearly covered by the provision of public procurement policy and consequent tender for the petitioner could not have been rejected on the ground that there being a failure on his part to deposit the tender cost. Now, Lordship will kindly take Millard paragraph 4. Having noticed the rival submissions, it would at the outset be relevant to notice the scope of the tender work, serial number 45 and 48. 45. Now these are, my lord, nature of work has been expressed. Para 6. The expression rehabilitation says was explained. The works for exclamation, dressing of the ark, including removal of the vegetable of all kinds, has quoted in detail. Now, my lord, works contract was defined there, my lord. That's, my lord, 1203. Now, my lord, kindly take paragraph 8. Be as it may, we proceed to deal with the contention. Advance on behalf of the petitioner on merits. Well, despite there being no provision for challenge, the court is going to decide it. The provision of section 11 of the 2006 Act relates to procurement of goods and services produced and provided by MSE. As evident from the name and nature of the works comprised in tender numbers 45 and 48, the contracts were not for supply of goods alone. Same as here. Both the contracts on their terms appear to envisage a contract of a composite nature involving both supply of goods as well as labor. The respondent therefore appeared to be correct in proceeding on the premise that both tenders were work contracts. We also note that the learned senior counsel appearing for the petitioner did not seriously dispute the classification of these contracts as works contract. The submission was essentially that even if it's a works contract, neither under the provision of the 2006 Act nor under the terms of the public procurement policy, such a contract was excluded. We find ourselves unable to accept the submission more for one reason. A reconstruction of section 11 bears out empowers the central government to formulate the policies, procurement of goods by MSME and service by MSME. The word service provides used in the provision marked must necessarily be read as disjunctive to the expression of the goods produced. It cannot be possibly disputed that the contract forms a complete different and distinct genre of the contract for supply of good. For a matter, the contract providing surface. A work contract is essentially an individual contract which may involve not just supply of goods but provision of labor and services. This particular species of contract has highly been understood by the railways as not to be ambit of the 2006 Act. In our considered opinion, the provision of 2006 Act and more particularly Section 11, therefore only contemplates things and brings within its folds contract for supply of goods and provision of services simpliciter. Answering a similar question in respect of this court, the Finance Act 1994, Supreme Court in CC versus Larsen and Toubro, which Millard I have just now placed from the Kone elevators Millard, I am not placing it again. This has been placed Millard. What is a works contract? Larsen and Toubro. Now Millard kindly takes paragraph 9. It follows Larsen and Toubro. No provision of the 2006 Acts bids us to deconstruct a work contract entered into elements relating to supply of goods and provision of services. Neither Section 11 nor public procurement policy appears to contemplate a distinct category of contracts such as work contract actually is. The classification of the tender under 40F correctly classified the respondent in terms of the manual to be contract. There was no challenge to classification. Consequently, we find no error in the judgment, etc., etc., and the Millard writ petition was dismissed. Millard, this is also followed by the Bombay Division Bench, which is the next judgment, Millard. It's Millard flagged G. Millard, which is Millard, Starling and Wilson. এটা বলে তুমি যখন বলছো বলে Millard, the contract in question, paragraph 4, that's internal page 2 of the judgment. Millard, undisputedly, the respondent number 3 is registered with National Small Industries Corporation and MSME Enterprise. The NSIC registration has been in respect of fabrication, etc., etc. Respondent number para 4, respondent number 2 on 19th October 2016 floats tender bearing number for firefighting and detection systems in its 2 plants. So this is the contract in question. Now Lordship will now take Millard paragraph nature of the work. Lordship will take Millard nature of the work contract or sale of goods. Para 11, internal page 3 top. This has everything, Millard. Lordship sees 19th October, Millard, respondent floated a tender for design, supplying, examination, lighting, erection, spray system, etc., etc. So, Millard, various types of work, Millard, was there. Para 12, there is no dispute that the above contract is unsplittable, undivisible, and it's a composite contract, just like us. Now, Millard, kindly takes Millard 17, 1717. This is Millard, the contention of Millard, the respondent. The learned counsel for the respondent in support of the award tended to have strongly relied upon the policy and memorandum and content action within the policy. And Millard, services have been quoted in office memorandum, services is recognized. Millard, the finding of the judgment, if your Lordship takes, these are all submission. If your Lordship straight away come, these findings, reasons, that starts from, now Kone elevators have been quoted in detail and followed. That's internal page 7, paragraph 23. These paragraphs, Millard, I have placed. Internal page 7, paragraph 23. Then Lordship Millard, kindly have a look. The reasons are from paragraph 24. Lordship will straight away come to paragraph 25. internal page 8, the second paragraph. It follows, my lord, both Larsen and Toubro and Kone elevators, my lord. That's quoted. All the parties are aware of the concept of works contract, which is recognized specially for the contract of engineering, procurement and construction contract, including sum sell package. The nature of work tender invited itself shows that the contract in question is to design, engineering, manufacture, procurement, supply. The scope of the contracts definitely falls within the ambit of the works contract. Now, Lordship will now, my lord, take 27. After considering the above admitted position, the law, the tender falls within the admit of contract. The respondent number 3 could not have awarded the contract to the respondent number 3 based upon the so-called memorandum clarification issued by the respondent number 4. The position of law, including section 2 and 11 of the Micro Act, makes it clear that benefit and or preference required to be given under the Act and the policy on the nature of works falls within the ambits of goods and services which are manufactured and reproduced by the enterprise. The nature of contract should be for sale of goods and such services. The composite nature of contracts falls within the works contract. Respondent number 3, therefore, is not entitled to get the benefit of the Act. Respondent number 2 has awarded the contract by giving benefit of the Micro Act, which in our view is impermissible and contrary to the policy so declared by the Micro Act. The memorandum and clarification, even if issued by the respondent number 4, is unacceptable in view of the specific judgment given by the High Court of Allahabad and Delhi High Court, apart from clear provision of the law of Micro Act and policy declared as interpreted in those judgments. Now, my lord, kindly take, my lord, paragraph 31. To sum up, my lord, it's internal page 10. To sum up, the provision of Micro Act and the policies are not applicable to works order. Hence, the respondent could not have taken any decision. Therefore, the decision of the respondent number 2 to award the tender to respondent number 3 is arbitrary and illegal. Now, my lord, the Honorable Second Judge also has a view that if your Lordship, my lord, takes paragraph 52, I just indicate the paragraphs. My lord, the judgment of Allahabad, Lordship will kindly have a look at para 41 onwards from page 16. I'm very sorry, my lord. Lordship takes, my lord. A plain reading of the provision, internal page 16. A plain reading of the provision clearly indicates that every central ministerial department undertaking under a mandate to procure goods and services under the micro medium enterprise, central government enlisted the following categories. Millard, this is the obligation of the central government is quoted. Now 42. The provision, next page, of section 11 of the Act and clause 3 of the policy, procurement of goods and provided. The provision of the Act and the policy are therefore applicable to procurements of goods and services provided by MSME. Answer to question number 18 makes it abundantly clear the policy meant for procurement of only goods procured and services from MSME. However, traders are excluded from purview of the public procurement policy. Now, Lordship will Rahul Singh, paragraph 43, the Honorable Second Judge says the provision of the Act would therefore not be applicable to works contract, which are essentially contract of composite nature involving supply of goods as well as labor, services, etc. Similar view has been taken by the Delhi High Court and 3G Enterprise, wherein it has been held that the policy is not applicable to works contract simpliciter and it is meant for good produce and services rendered by MSME. Now, Rahul Singh, my lord, is the Allahabad High Court bench, my lord. It's quoted in quite detail. Lordship will straight away come to paragraph. Lordship will also consider, my lord. Kindly have a look at quite detail. The clauses of the contract has been construed, para 42. A perusal of these clauses, para 52, page 22. I'm sorry. Perusal of these clauses reveal that the contract under the tender is a composite contract which involves supply of goods as well as erection, installation, commissioning in accordance with plan, drawings, procedure, and specific specification. Page 92, Lordship will find all the details have been given. The nature of work requires expertise, special skill in designing, engineering, and various other technical aspects in erecting, installing, commissioning, and making fire water spray operational and functional. The tender contract of this nature is not for sale of goods simpliciter, but it's a composite contract which has to be treated as works contract. Then last sentence 2 is again quoted. Millard, I am not placing it, Millard, and cone elevators is 54. Lordship will now, Millard, straight away come, Millard, to para 56, internal page 24. In the instant case, as stated earlier, the contract under the tender is a composite for supply of goods as well as for installation of fire water spray, which is a permanent fixture. Now, Millard, wet basin flap gate affixed on a, Millard, wooden beams, shawl wooden beams, Millard, is a permanent fixture of the present contract. Because it's a flap gate, Millard, you take it out, water comes in, again, Millard gives the water, Millard goes out. The goods supplied and the contract are eventually assembled, installed at the site and becomes part of a permanent fixture. The said contract satisfies the fundamental characteristics of a works contract and hence cannot be considered as a contract simpliciter for sale of goods and services. Then, Millard, I'm squarely out of, Millard, any event, Millard, the first, I could not have gone there, any event. Now, Millard, 57. As stated earlier, MSME Act and public procurement system is only applicable to procurement of goods and services. The contract of tender, not being a contract for sale of goods, predominant work contract, the benefit of the Act and the policy cannot be extended to the MSME registered under the Act. Clause 15 of it is not in consequence of provision of the MSME Act and thereunder, etc., and Millard, the writ petition fails. So this is an pressed into operation even at the time of tender also. And Millard, and there is the last judgment which Lordship I indicate the paragraph which is cited all over. Adke versus Millard, Wardha Municipal Corporation. It says, Millard, it's a single bench. It is being SLP is preferred therefrom, which is, Millard, pending, Millard, which is, Millard, the first step. And Millard, this Bombay judgment, Millard, is before the Supreme Court in question. These are, Millard, by respectful submission. Oh, যেটা last step দেখেন ওইটা দেখেন যেটা 3 bench, 3 bench Millard, I'm sorry, Millard, the 3 bench which I said will, and just 2 sentences there. কিনে যাচ্ছে তুলে তো খুলে গেলে জজ সাহেবকে দেবো কি করে আমি আরেকটা দাও বেঁধে দাও আমারটা তো একটু না অন্য দিক দিয়ে একটু স্টেপল করে দিন, অনেক মোটা জাজ ক্লিপ লাগিয়ে দিন না, এটাই দিয়ে দাও, না লাগলে এই ক্লিপ লাগানোটা দিন, ওটা আমায় দিন। আর এক ক্লিপ আছে This is 2025 3 SCC 440. This is also a 2-bench judgment. Lordship will kindly have a look at 2025 Volume 3 Supreme Court Cases 440 NBCC versus State of West Bengal. Lordship will straight away come to paragraph 25, paragraph 24. MSME একটা বার করে রাখ। Millard, it's Millard, page number 460. The first and foremost chapter 4 of the Act deals with delayed payment to micro and small enterprise, which specifies the liabilities, recoveries, remedies in favor of micro small enterprise. The rights and liabilities are based on the incidence of supply made by micro and small enterprise. To this extent, the Act continues the statutory scheme contemplated under the repeal statute and therefore the principle laid down in Shanti Conductor that the liability of the buyer commences from date of supply and not from the execution of contract, even though the contract was prior in force, continues to apply. Up to this point, there seems to be no difficulty. The issue in the present takes a different turn as explained in the following parts. Now, we'll at para 25. Whether registration is necessary precondition for referring a dispute under the section 18 of the Act. The question we are called upon to answer is whether reference to the Facilitation Council under section 18 of the Act is impermissible if the enterprise is not registered filing a memorandum under section 8 of the Act before the contract is executed. This issue was not formulated, described and decided in any other judgments of the court, including two substantive judgments under the Shilpi Industry and Mahakali Food. In those two judgments, it is worth mentioning such an issue was neither formulated nor discussed. We explain in detail the discussion of the facts and the ratios. Next, paragraph 26. Apart from the submission of the appellant that the issues arising from the consideration is covered by Shilpi Industries as approved by Mahakali Food, our specific inquiry as to under which provision of the Act an enterprise which has not filed memorandum under section 8 would be barred for invoking under section 18, Mr. Such and Such made the following submissions. According to him, section 18 provides that any party to the dispute which may take reference to the Facilitation Council, the said dispute must be with regard to any amount under section 18. The requirement he would submit to us to take section 17, which provide for the goods or supplied or service rendered by a supplier, the buyer shall be liable to pay the amount with interest under section 16. Section 16 is the liability of the buyer to pay interest on the supplier on the amounts payable to it under section 16 of the Act. Rendering of services. The expression supplier mentioned in section 15, 16, 17 is defined under section 2N. A micro or small enterprise which has filed a memorandum with the authority under subsection 1 includes. It was submitted that the supplier can only be an enterprise that has filed a memorandum under section 8 of the Act. He could conclude by submitting that the supplies made prior to the registration enterprise cannot avail the provision under the Act. Now we examine. Now Miller kindly take paragraph 29. The text of paragraph 18 is clear and categorical. The words employed herein, any party to the dispute, the text any party to a dispute cannot read as a supplier by adopting the process of interpretation by first referring to section 17, then to section 15 and 16, and thereafter in search of the definition of the supplier, section 2N, and finally stopping at section 8 to hold. Any party to a dispute will only be an enterprise which is registered under section 8 of the Act. This meaning making the process to be metamorphosed, the clear text any parties to a supplier is not a legal method to understand the true meaning of the word employed in the legislation. The age-old principle referred to as the golden rule of interpretation, the word on statutes has to be then understood natural, ordinary and particular. Sense, the choice of words, any party to dispute in the section 18 to dispute is deliberate. The legislative device for employing different expression in the successive provision of the same statute is well known, intended, effectual, detailed purpose. Now, Millard, kindly take Millard of the Act next page. If the Parliament has intended that any party must be confined only to the supplier, even a buyer, which expression is also defined, it would be have to those expressions. The court cannot substitute any party with the supplier and change the constitutional scope and ambit of section 18 altogether. The mention of section 17 and 18 is only to provide the context for reference of dispute. The contextual relevance located in section 17 is only to provide for reference and not to confine the remedy to the registered enterprise. It is to clarify that the reference shall be adjudicated and the dispute as a liability of the buyer which is declared under section 15 and 16. Now, purpose of section 18, paragraph 31. Apart from the text and the context in which section 18 of the Act employs any party to dispute, it is also to be seen the section is provising a remedy for resolution of dispute. This remedy is provided by the statute, not by the agreement between the parties. It is therefore necessary to keep it unrestricted, open-ended, enabling a party to a dispute to access the remedy. When the statutory provision incorporating the remedies for resolution of a dispute falls for consideration, the Constitutional Court must interpret the remedies in a manner to effectuate access of justice. Now, Millard, definition of supplier is quoted, Millard. Who are the suppliers there, Millard? That is quoted here. Now, Millard, kindly take Millard, paragraph 33. plain reading of section 2N, it is clear that definition of a supplier is relevant only to a micro or a small enterprise and does not encompass a medium enterprise. The supplier not only means a micro or a small enterprise which has filed a memorandum with the authority referred to under subsection 8, but also includes NSIC, SIDC, three company, cooperative, trust body engaged in selling of goods by the micro and small enterprise rendered service which are produced by such enterprise. In the other words, a supplier will also be an entity engaged in selling of goods and rendering provided by micro small enterprise. All entities such as irrespective of filing of memorandum with the supplier. Thus, the definition of a supplier encompasses not only those who have filed memorandum but also who have not filed. The reason keeping in the find is not difficult to manage. Still, it is unorganized industry, knowing evolving the many startup. The reasons keeping the definition supported by the expert committee. Now, my lord, kindly takes me lord this where my lord registration is quoted 465. Page number 465, paragraph 37. The aforesaid extracts of the report of the committee clearly indicates that MSME still exists as an informal sector and it's also recognized the registration offers them little by way of a tangible benefit. The committee has also recognized that even though simpler modes of registration have been introduced, they usually are not enough. It further suggests that filing of a memorandum provides information of the nature of business, location, segmentation as to the regulators can capture information on operational units. Para 4.5.1 also recognizes the policy of lack of formulation. It is expected over a period of time of memorandum can be intrinsic part of MSME itself. The aforesaid committee report as well as other documents clearly establish at no point of time filing of a registered MSME was ever considered as a precondition for availing benefit of the resolution under section 18. We have noted that clear feature of statutory regime to start with section 18 does not use the word supplier, instead employs any party to dispute may. We have also noted the definition supplier is not complied to micro or small enterprise which has been memorandum of 8.1 which includes the companies or other entities selling in the rendering by an enterprise. Now, Miller, thirdly, next page, section 8 grants a discretion to the micro small enterprise in filing a memorandum with the authority. It is noteworthy that micro under section 2.8 small, section 2A medium enterprise, 2G forms an existence is simply of their investment as provided in section 7 in relation to an enterprise. They subsist without any formal recognition or consent or registration. The Act uses the expression filing of memorandum. That is all. That to the discretion of the micro and small enterprise, cumulative account of the features compelling leads us to the conclusion that the application of micro small enterprise facilitation as cannot be rejected on the ground the said entity cannot be regarded as registered in section 8. Now, Millard, kindly have a look at Shilpi Industries. That's Millard, paragraph 42. This led us to the judgment which has been given in the impression that this court has laid down that section 18 cannot be invoked by the enterprise if it has not filed a memorandum under section 8 of the Act before entering into a contract. However, the issue that arose for consideration in Shilpi Industry are in complete contrast with the present case. In that case, there were two appeals. They involved different facts and circumstances. The short facts in the first appeal where the appellant referred the matter to the Facilitation Council and made an award in favor of the appellant under the Arbitration Conciliation Act. The award was challenged under section 34 and the same was dismissed. During the pendency of the appeal under section 37, High Court decided a preliminary issue as to whether limitation would apply to arbitration proceedings under MSME. In the appeal, the issue arose before the High Court whether there is a right to file counterclaim in the arbitration proceedings. The High Court answered both the issues in the affirmative. Appeal before this court in Shilpi Industries. Now, Millard, kindly take whether the provisions of Limitation Act are applicable to micro small scale industries, whether counterclaim is maintainable in such arbitration. On the first issue, 42.1, the relevant portion of the order is under. We are of the view that no further elaboration is necessary. We hold the provision of Limitation Act will apply to arbitration covered by 18.3 of the Act. We make it clear that as the judgment of the High Court is an order of remand, we need not enter into the controversy whether claims, counterclaims are within the time or not, we keep it open for the authority to go into such issue and record his own finding. On the second issue of Silpi Industries, the counterclaim is maintainable, the relevant portion. For the above reason, a harmonious construction of 18.3 of 2016 and 7.1 Act 2023A of the Act, we are of the view that the counterclaim is maintainable before the statutory authority of the MSME Act. So this has been held by the Shilpi Industries, which is a 2021 judgment, Millard. And my Millard proceedings, independent before the Honorable Arbitrator, was in 2017. So that time there was no Shilpi that I could have Millard shown Shilpi and gone there and made that claim. This is clarified in Shilpi. Because my reference is 2017. And Shilpi is decided 2021 18 SCC 790. So it's a 2021 judgment. Exact data bullet. May I start? In view of the finding of Shilpi Industry, the Limitation Act will apply to MSME arbitration and counterclaim maintainable in MSME arbitration. The court have disposed of the appeal as nothing further remained for adjudication and determination. However, it appears that the respondent seems to make an argument that the appellant in the period of the set of appeal is not entitled to any relief, led to making the observation. Now, paragraph 41 is quoted. Though we are of the view that the counterclaim and set-off is maintainable before the statutory authority under MSME Act, the appellant in this set of the appeal is not entitled to be relieved for the reasons that on the date of supply of goods and services, appellant did not have the registration by submitting the memorandum as per section 8 of the Act. Next, this fact led to the court in Shilpi Industries rejecting the claim of the appellant. There was no supplies after registration under section relevant portion of the Act is quoted. Though the appellant claims benefit of the provision of the MSME Act on the ground the appellant was supplying data plate provided under section 8 of the Act, same does not be an acceptable material. The appellant in support of the case has laid reliance on the Delhi High Court judgments, whether it is quoted in detail, Millard. The Shilpi is quoted in detail. Now, Millard, kindly take paragraph 43, the next page. In the first place, whether an enterprise is disabled from seeking a reference before filing of memorandum under section 8 for registration never arose in Shilpi. More particularly, the court did not examine any provision of the Act and their implication on the right to seek a reference under section 18 of the Act. This was natural because the court did not frame the issue of registration. On facts, court held that there was no proof whatsoever the appellant has made any supplies as contemplated in Shanti construction case. Though we are concerned about the interpretation of the Act, we may mention that every stage is an admitted fact that the respondent has in fact raised 41 and 53 after registration on such and such. Be as it may, we are of the above referred analysis, we are of the opinion Shilpi is not an authority on the issue that a reference under section 18 cannot be made by micro small enterprise if the supplies were made or the contract executed before the filing of the memorandum under section 8. Re Gujarat State Supply. Well, 3 paragraphs are put in now. This case we have considered the batch of appeals. Arise as follows. Millard 1, 2, 3 has been quoted, Millard. The issues. I am not placing it, Millard. Now, Millard, issue number 3. Whether micro small facility could take up the dispute for as an arbitrator, this is. Now, Millard, kindly take 45. It is evident from the above substantial question for consideration arose for consideration in Mahakali Foods as whether MSME provides overrides Arbitration Conciliation Act. Such incidental question, there was no issue whatsoever has arisen in our case that our right or rather disability to seek a reference under section 18 if the enterprise has not filed a memorandum. The answer to the issue have arisen for consideration. Supreme Court, Millard said that. Millard. That is Millard, ABCD, Millard, what Millard? I had Millard, showed Millard from the earlier judgment in question. The paragraph 46. Kindly have a look at paragraph 46. The court in Mahakali Foods reached another conclusion in 52.6 as follows. A party who is not a supplier, as per the definition contained in 2N of the MSME Act, on the date of entering into a contract, cannot seek benefit as a supplier under the MSME Act. If any register is obtained, same would have an effect prospectively and would apply to supply of goods rendering subsequent to the registration. Something similar in Silpi industry transpired in Mahakali Foods, even though the issue of registration did not arise. A submission was made to the following effect. One of the submission made by the learned counsel for the buyer was that if the party supplier was not the supplier within the meaning of 2N of the Act on the date of the contract entered between the parties, it could not have made a dispute to micro small scale facilitation under section 18(1) of the Act. In such case, the council would have the jurisdiction to decide the arbitration. In view of, next page, Miller. In view of the above submission, the court proceeds to rely upon Shilpi Industries and allowed the prayer of the relevant portion under the Mahakali Foods. Miller, paragraph 50 is quoted. 51. The following observation ratio, it is held that a party who was not a supplier under 2N of the Act on the date of entering into contract would not seek any benefit as a supplier under the MSME Act. A party cannot become a small enterprises claim benefit under the MSME Act, submitting a memorandum and obtain wages subsequent to entering of the contract and supply goods or rendering service. If any registration obtained subsequently, same would have the effect prospectively and would apply to goods of service subsequent to the registration. Same cannot operate respectively. However, such issue being jurisdictional issue is raised shall be decided by the arbitrator. Now, Lordship, kindly take Miller, para 49. It is evident from Mahakali Foods, the issue which is arising for our consideration never arose, neither an issue and decision nor analysis on the applicable section 18 of the enterprises have been filed a memorandum. The decision of certainly an authority on the issue which formulated para 11 of the judgment which have been extracted above. Even concluding the paragraph mark, it clearly established the fact the court was only considering the issue whether MSME Act being a special legislation overrides the Arbitration Act or not. The relevant portion of the judgment is set out here under. Miller, that is set out. Now, Miller, apart from Silpi Industry 50, Mr. Shankar Narayan relied on two orders such and such. These orders do not lay down the law but follow the decision of the Shilpi Industry. So there are two more. That is Miller Vaishnav Enterprise versus Nilesh Estate, which also blindly follows Shilpi. In Vaishnav Enterprise, the contract was entered into on 24/8/2020, but registration was made on 28/8/2020. The court held that the appellant was not an MSME and therefore the act will not apply. Next, the order seems to have been made in the facts and circumstances of that case. Next, there was neither an issue about supply of goods nor formulation of the question whether filing of a memorandum is mandatory for invocation of the reference. Now, Miller 52. The order in Nikhil Estate was also relied upon. Observe that the issue involves in squarely covered against a respondent in view of a decision in Shilpi Industry, holding that filing of the NDA is mandatory for initiation under section 18. So there is a finding in Nitesh that there should be a memorandum. A decision whether such an issue is neither raised nor preceded by any consideration of the Supreme Court. Now, Miller, kindly Miller, these are Miller on Miller decision-making process, and ultimately, Miller, the conclusion is Miller, paragraph 56. The issue was referred to a larger bench, Miller, in respect of these four judgments of coordinate bench. Our interpretation on the aforesaid provisions of the Act, we have arrived at a clear opinion and have expressed the same. Though it is possible for us to follow the precedent referred to in paragraphs 53 and 50, arrive at the conclusion in judgment in Silpi and Mahakali, coupled with the subsequent orders in Vaishnav and Nitesh, cannot be considered to be binding precedents on the issue that has arisen for our consideration, taking into account compelling need to ensure clarity and certainty applicable precedent. We deem it proper to refer it to the 3-judge bench. So, Millard, there are 4:1. The situation is now, Millard, 4:1. Found? Which so, Millard, 3 points. এখান থেকে বার করবো, এখানে খোলা আছে। এখান থেকে করো না। Millard, the 3 points, Millard. A, Millard, is a dismissal on jurisdictional point. The award has been set aside on the jurisdictional point only. It's not an MSME. But Millard, the points one has to consider: two-way supplier, keeping in mind of Shilpi and Millard, 3 others, Millard. Date of registration is, Millard, according to the judgments, Millard, are, Millard, one of very essential. 1 stray line is there, 2 stray line, and the supplies made thereafter. There are 2 subsequent, Millard, Supreme Court judgments which relied in, Millard, the last one, 2025. It says, Millard, that look, without, Millard, registration, you cannot get benefit of the MSME Act. You don't become a supplier within the meaning of two-way. Second point, Millard, it's a works contract. So, Millard, any event, even if he is registered, even, Millard, I take, Millard, the 2025 3, Millard, stands, Millard, that is what is now, Millard, holding the fort. A dispute in respect of a works contract cannot be, Millard, sent to MSME. That is, Millard, Cone Elevators and Larsen and Toubro, which has been followed by division bench of, Millard, Bombay and, Millard, Allahabad, and followed by a Bombay single bench where there is a SLP, there is no stay. Millard, third point, and the third point is, Millard, the third point is, Millard, it's a commercial dispute. A dispute which is defined under, Millard, section, Millard, 2C1, 6 and 18. So, Millard, the order, it was that point of time, commercial court was in season of the division, was in season of the matter. So, Millard, it's not a pending proceedings, but a new proceedings filed. Under section 15, it cannot be transferred. Millard, there are, Millard, Lakshmi Uddog, Millard, Polyfab says, a single bench, of course, that, Millard, new proceedings cannot be transferred. It can only be dismissed. And, Millard, it is taken in note, Millard, in party automation also. Now, Millard, this is the position in law. And so far as the counterclaim provision, if your lordship takes, Millard, what the Supreme Court says in it, so far as the counterclaim is questioned, judgment the counterclaim in question, if your lordship takes, Millard, the Act, Millard, MSME Act, Millard, the provision of section 23, when it came into force. Boita daw? MSME boita daw, section 23, boita kota. Just please. Thank you. কোথায় গেল বইটা? বইটা রাখবে কোথায়? হয়ে এসছে স্যার, হয়ে গেছে স্যার, আমার আর নেই। বইটা কোথায় রাখলে? থ্যাংক ইউ, থ্যাংক ইউ। হ্যাঁ, করে এসো। ওটা দেখাবো, আননেসেসারি জিনিসপত্র দেখছি। Lordship will kindly have a look at the Act itself. Lordship has a MSME Act copy. Millard, my reference is dated 23rd of September 2016, wherein, Millard, I had appointed an arbitrator. So, Millard, it has to be seen, Millard, in this context as on prevalent on that date. Not, Millard, on today, Millard, what is the scenario. If your lordship takes, Millard, section 18 of the Act, first look at the definition, who can go. Section 2N, clear. A supplier can go. Along with that, there is a category 1, 2 and 3. Supplier means a micro or a small enterprise which has filed a memorandum with the authority referred to in subsection 1(8) and includes National Registration Development Corporation, small scale industry, any cooperative, etc. So these are the 3 persons, Millard, categories which can go. Now, Millard, reference is section 18. Notwithstanding anything contained on the law being force,
any party to a dispute with regard to any amount due under section may make a reference to a micro small scale industry. So he should be a party within the meaning of
E.
reply to বলবো আর কি করবো
Therefore, it is not mandatory. That is one of the. But definition of supplier would only apply when there is a supplier means the parliament has defined a supplier. Small, which has you don't find whatever. Yes.
Yes. Just Lordship, give me 1 minute. I have missed out.
Mr. Chaudhary will keep us occupied for the rest of the day.
Yes, yes. If he finishes, I'll finish it. Yes.
So we can.
I am more or less finished.
Let your other friends go.
Yes, I'll take
You'll take the rest of the day.
So much of argument has been made. I
Yes,
thought I
yes.
would not take more than 15 minutes, but he has argued what is not there in the petition also. So let me answer that.
At least till 4 o'clock, we are permitting you to go. Acha, released. Go.
Lordship can release, my lord. I'll
Release,
take up.
Go. Huh.
Pleasure. Millard, if your lordship, Millard, comes back, Millard, to page 467 of the Millard 2025 volume 3 SCC 440. Now, Millard, there is an amendment giving right of the parties, a party who is not a MSME perhaps, subject to correction, to make a counter claim before the MSME Council under section 23(2)(a) of the Act. This is by way of an amendment. But Millard, I have to only check that. I am checking that when it came into effect. 23, that's Millard Supreme Court records in no uncertain terms in paragraph 42.2. 23.2a of the 19, there is a provision for counterclaim also. That's 22.23.23 2 capital A. Has my lord's book, has that, Millard? My book, Millard, doesn't have it, Millard. Millard, I have to only page the Arbitration Act. Oh, it's Millard, perhaps the Arbitration Act, Millard, they are quoting, Millard. Because MSME Act, Millard, doesn't have it, Millard. It should be the Arbitration and Conciliation Act. It's a harmonious construction of 18.3 of the 2006 Act and 7.1 and 23.2a of the 1996 Act. That must be the Arbitration Act.
Yes, must be.
Must be the, because MSME Act did not find, junior is correct. I did not. So if Millard, this is a opinion of Shilpi, because prior to this was Millard, as Lordship Millard asked me the question, could you have gone there? My reference is 2016. Shilpi is 2021. So Millard, how could have Millard gone Millard and make Millard that reference before? Because it's Millard a situation which is pre-Shilpi Millard. I say Millard, it's a pre-Shilpi reference Millard. So Lordship has to see it on the touchstone of that case in question. So these are my respectful submission, Millard. And Millard, point of law, Millard, I have argued it's well settled, Millard. I can raise the points. No. Oh, I also, Millard, formally, Millard, cite Millard. তিনখানায় যাচ্ছে the judgment একখানায় দুখানায় যাচ্ছে একটা কপি দাও দাদা the mail করো ear drop করে দাও Millard, this Millard, it said Millard, the order has to be set aside, my lord, and this is what has been said. It was a pending proceeding. The morning I showed, my lord, the judgment. It was a pending proceedings, old suit. So, my lord, it was, my lord, transferred and, my lord, required, please do all the formalities which is required, my lord, under, my lord, section 15 of the and read with section 13 of. So these are my respectful submission, my lord. After he finish, I will be joined. Grateful. Great.
Essentially, 3 points I have to answer. One is the commercial court part. Second is MSME and the ratio of Shilpi. And the third is what is the effect of a subsequent Supreme Court where an earlier view has been referred to a larger view. For a prima facie, assume for a moment, my lord, I'll come to that. I'll make my submissions on the 2025. But it is settled law that, my lord, so far as Supreme Court is concerned, reference to a larger bench doesn't obliterate the law which is till down applicable, even as on date, my lord, that is binding on your lordships or honored in any high court. So, my lord, whether it has been referred to larger bench or not, my lord, the
Yes,
law,
but for the simple reason, a two-judge bench cannot overrule another two-judge bench.
correct. So it is there.
Yes.
So as of now, my lord, Shilpi ratio remains unchanged. But, my lord, I'll come to that later. My lord, kindly see, my lord, this point was not taken. So when in the morning my learned friend took it, I was caught by surprise. Because, my lord, at that point of time, the learned judge was exercising determination both of the commercial division and in the regular division. So there was no problem in that. In fact, at that point of time, Mr. Siddhartha Banerjee was there for the other side. So, my lord, we had a discussion also, and we felt that it was because this is the reason why. Lord, the date given to your lordship is perhaps, my lord, the date that is there in the placard which is outside. My lord, in this floor and outside, Justice Matre had inaugurated the commercial division. September 2018 is the placard, is the marble slab which is there in the corridor if we just walk outside the court. Lordships will not have the occasion to come there, but there is a marble placard over there. The date is there. That is the date that has been given. Now, it may be, well, but this is, well, Lordship will find 20th March, this notification comes, 2020. And, my lord, 2018 at that point of time, my lord, it was perfectly, according to me, it was perfectly all right. But be that as it may, my lord, since the same judge had determination, it was only a technical or procedural part. It is not unlike other cases where if different courts would have been there, and my lords are also, the commercial lordship is also taking up commercial division matters, commercial appellate court, and, my lord, commercial division. So, my lord, it will not matter if at all, my lord, let us say this is not correct. This is, my lord, I could find out. And I am only trying to, my lord, hazard a guess that why it did not happen at that. Because nobody raised it. So, my lord, this is a point, and it is not there as a part of the, even in the memorandum also, no ground has been taken. But since he has argued, my lord, this is my answer, that, my lord, especially in arbitration, my lord, this was done later. Otherwise, my lord, the same judge was discharging both. It would only have been, my lord, either first half or second half, or instead of Monday, Tuesday. That would have been the only difference. Nothing more, nothing less. So, my lord, this is one aspect of the matter. Even if, let us assume that the division was there, all that lordship will do is lordship will treat it as a part of the commercial division. Because, my lord, not only this bench has the jurisdiction as the commercial appellate court, but even, my lord, the learned judge, I'll try to produce the list, my lord, of Justice Bhattacharya at that point of time, and lordship can take it from me. She had both the divisions. And, my lord, lordship will find, my lord, the first notification is saying with immediate effect the commercial courts at Calcutta. So prior to that, my lord, it was to be set up, but in practicality, my lord, we did not have it. And my lord, my learned friend is right. The formal inauguration was done in 2017. I am not joining issue over it. But my lord, be that as it may, my lord, I am only showing, my lord, I am only on this notification. This is one part of it. But my lord, it does not really matter because my lord, procedure and my lord, especially when my lord, the same judge had determination whichever way lordship look at it. So it is not that I had to file somewhere else and all. This is of both are in this court. It's only one division to another. And well, it's like the original side and appellate side. If it's the same high court. It is unlike my lord other matters where it could have been a different because my lord in commercial suits because of section 12A there are different considerations whether you can file it or not. So my lord, this is my answer so far as the first point is concerned. Now, my lord, before I come to
So this is not a case where the learned judge did not have determination to take up commercial matters. This is your argument.
both the divisions were there, my lord, and nobody raised it perhaps because of this. Be that as it may, my lord, I don't join issue over here, my lord. You can't spring a surprise. This cannot be a point, my lord, when you have also not raised. And when the learned judge herself had the determination, my lord, so far as even commercial matters are concerned. And that is not there even in the memorandum of appeal. But I am not saying he cannot argue. Now, my lord, now comes, my lord, factually. My lord, kindly takes the Arbitration and Conciliation Act. Before I come to the facts.
1 second. Mr. Chaudhary, please clarify something. The plaque and all that, the formal inauguration, I was present personally, I remember, I have photographs, was 2018 or sometime there.
2017 September.
17 September. This notification is of 2020. What does this notification say? I mean, between 2017 September and the date of this notification, was the commercial court not functioning?
In a limited capacity, perhaps not full-fledged. But my lord, I must be candid, my lord. There, I am not saying it was not functioning in a limited capacity. But this is, my lord, this is what I could find out.
No, the jurisdiction or power of the commercial division to function did not stem from this notification, did it?
No. It's statutory. But my lord, this is what, my lord, in arbitration and all, my lord, whether the commercial division was there, my lord, at that point of time, my lord, because in the morning he has raised the point, my lord, I must be candid and it's not there in the memorandum of appeal. I have been taken by surprise, but be that as it, this is what I could find out thereafter. I am just giving it. But I'll also check it up. I'll check the determination. But I have a simple answer, my lord. The honorable judge had the determination. So it's only a technical issue. It would have been the same judge, only, my lord, it's a procedural aspect. And lordship has the power, my lord. Under the appellate court, my lordship also has both the determination. Lordship can treat that as an order under command. If at all, my lord, what situation? That doesn't, my lord, it is not a question of remand because, my lord, the same judge had it. Now, my lord, comes the second aspect. Lordship will see, my lord, the Arbitration and Conciliation Act. Kindly see section 23A first.
A 23A or 23-2A?
2A, sorry.
2016 amendment.
2016 amendment with effect from 23/10/2015.
Yes.
So, my lord, respondent in an arbitration proceeding can also claim or file a counterclaim or set off with effect from 23/10/2015, my lord, settled. The Supreme Court interpretation does not make a law prospective or retrospective. Law is prospective or retrospective when it comes in the statute. So Shilpi was in 21 or 22, it does not alter the situation. Now, chronologically, I'll tell in brief what is the matter. So there was a contract. My client was entrusted with the job of repairing a flapgate basin. Well, the flapgate basin, I'll indicate in just 1 minute what it is. Well, a flapgate is a gate which, my lord, makes the dock watertight. Well, when a ship is repaired, well, for the bottom of the ship to be repaired, my lord, it needs what is known as a dry dock. Therefore, my lord, before it goes to the dry dock, there is a flap gate. Once the flap gate is closed, it, my lord, sort of cuts off the other water, my lord, from the river or sea, where as the case may be. And, my lord, the water which is inside, that is drained out. And then, my lord, the bottom of the ship is exposed and the necessary repairs can be carried out. Now, so far as this is concerned, in the flap gate, when it is closed, well, at the bottom of the ship, which was the subject matter of the repair, that their only allegation, this is on merits. I need not trouble your lordship because, my lord, I show, my lord, on merits, my learned friend did not submit. The witness admits that he has not suffered any damage. That is on merits. I'll come to that in prosecution. Why this came, I'll tell your lordship. My lord, we were chasing hard for 3 invoices because, my lord, in this case, not only we carried out the work, the performance guarantee was returned. The warranty period expired, the performance guarantee was returned, but my bills remain unpaid. When we were asking for payment of our bills, Lord, they said that no, we are not going to pay. And it is in this context, my lord, we went to the MSM. I'll come to the registration part. In that, my lord, we had also filed a writ petition. And since the writ code, I'll show your lordship, my lord, Justice Doctor's order, the writ code said that, well, you have yourself gone to MSME. Therefore, disputed questions are there, let it go for arbitration. At that juncture,
this is Dotto, not Justice Boshak.
No, Justice Dotto. First Justice Dotto, then Justice Boshak. I'll come to that. Justice Boshak, my lord, that was at the second tranche. My lord, it is then when we are asking payment, my lord, for the first time they are making submissions that we have a counterclaim. That is recorded. And they said, all right. And I indicated to the court that before I came, there was no counterclaim. So, all right, in law, if you have a counterclaim, you have, that's recorded in the order. I'll come to that. I'm just giving a brief sequence. But we go to MSME. They stop participating in MSME, saying that you don't have the jurisdiction to hear my counterclaim. I have a counterclaim, you don't have a jurisdiction to that. And then what they do, after the MSME is invoked, thereafter, my lord, they refer their counterclaim, my lord, to the chairman and invoke the contractual arbitration, which had a unilateral appointment clause. At that time, Parkin's judgment had not come. But all these arguments are academic because the arbitration clause doesn't survive. Because I'll show your lordship the arbitration clause. But we did not have occasion to raise this because this was already set aside on another ground. I'll come to that. So, my lord, after I have gone to MSME, High Court, all this is happening. In High Court, for the first time, they have a whisper of a counterclaim. And then, my lord, they refer to the chairman, who appoints, I won't say their own arbitrator, but, my lord, an arbitrator is appointed. Put it that way. And, my lord, we go before the learned arbitrator. We take the point of section 16 that, look, section 18 of the MSME is a non-obstante clause. It overrides contractual arbitration. And once it's an MSME, only the facilitation council has the jurisdiction. Before the arbitrator, and I show the section 16 order. Section 16 order says, it doesn't say MSME doesn't have jurisdiction. It says that they cannot file a counterclaim over there. We had shown 23A was there. They cannot file a counterclaim over there. Since they cannot file a counterclaim, this is a more comprehensive proceeding, therefore I have jurisdiction. Now, under the law as it stands, I cannot challenge a section 16 order and come here. So I had to suffer that one-sided arbitration proceedings. I don't make any further comment in that. Where the witness is coming and saying that yes, there is no complaint about the working of the ship. We have released the guarantee. What is the basis of my claim? It is in future. If any claim arises, we are securing that money. And in one question, so you have not suffered any damages as on date. Answer is no, we have not suffered any damages as on date. After 4 years of commissioning, the ship was commissioned, it's still running. After 4 years of commissioning before the arbitrator, the witness is saying, I have not suffered any damages till. What was falling from your lordship? Got it done from others? Risk purchase, all that? Nothing. Defect liability for 24 months, defect liability over my performance guarantee returned to me. But the bills were not being passed. This is factually. I am just indicating. It is not that, the reason why I am indicating is, it is not that on technical grounds I am trying to steal a march. No. So while this is where it stands, the learned arbitrator on merits doesn't refer to the ones which was discomforting to him. Because he has to pass the award, he passes the award. So we challenge it under section 16, my lord. We challenge it. Because section 16, I can only take it as a ground in 34. And the ground in 34, and in the meantime, my lord, I was successful in getting an award from the Facilitation Council. They challenged that award in the Alipur court. In that, my lord, initially I succeed. They come up in High Court. Well, it is again remanded back over there for a different reason. Well, apparently the learned judge, we were taken by surprise. Last 10 paragraphs of all 34 orders were identical. So the division bench, my lord, even if I could, before I could open my mouth, I told the, my lord, other division bench that it's an award. The award is there. Kindly do not, well, the clock has been put back by 7 years. But be that as it may, now again I have to go there. This is the agony. Why these, and my lord, these public sector undertakings, my lord, they take all sorts of points. Now, lordship will take it from me, the point of works contract. Not there in 34. Not before the arbitrator, not there in 34. And there is a reason. It comes in because, my lord, after 34 in Alipur court, that Bombay and that judgment, nobody looks into what that section is. One stray paragraph, works contract not covered by MSME, is referred everywhere. It has been followed by few other high courts. It was being referred. So, my lord, we prepared a full compendium of cases, and I'll show what is the basis before the Alipur court. Luckily for me, in the meantime, our High Court had the opportunity to consider this, and I'll rely on a judgment. We have a judgment of Justice Shobhoshaji Bhattacharya, that completely, my lord, settling the law on this. It's a single bench, of course, my lord, that it is, there is no embargo under the MSME Act. MSME Act, lordship will not find any distinction on works contract. This is a red herring which is springed, my lord, it is just lifted whenever all doors are shut. Works contract was the last resort. Lordship will not find a single sentence in the section 34. They also did not treat it as a works contract. And my lord, why? The reason. My lord, Kone elevators, I am giving you, my lord, I can cite the cases of works contract from 1950. It's a constitutional issue. Why the works contract came? My lord, Article 366. The concept of works contract was, my lord, formulated because, my lord, earlier lordship knows there was a sales tax act and a service tax act which were separate. One was under the central government domain, one was under the state government domain. So, my lord, at that point of time, my lord, the earliest Supreme Court is Gannon Dunkerley, the company which makes the conveyor belts. Then came the Kone elevators. My lord, all these, my lord, either horizontal lifts or, my lord, vertical lifts, my lord, they had the element of both supply and service. So the question arose that it's a turnkey contract. So how do you apportion, so far as the tax component is concerned, which part is sales and which part is service? Because the quantum was different. And it is in that context that the Supreme Court formulated or this law pertaining to or this expression works contract, my lord, it came up. Works contract which has both the elements of a service contract and a sales contract. So, my lord, what is over here? Why is works contract outside? If I am, let us say, if I am in, it's a beneficial legislation. It's a beneficial legislation so that, my lord, small workers or small, my lord, entrepreneurs are not, my lord, harassed. Their bills are paid. And if you don't pay the bills, you have a penal rate of interest statutorily recognized where you will have to pay 2 times above the bank rate. That is what the MSME Act is. And prior to the MSME Act, there was the Interest on Delayed Payment Act on Small Scale Industry. 1993 Act was there. I'll show that. Because this law, which Shilpi it only settled the law which was there in the earlier statute also. Even under the interest of delayed payment of interest act for small scale undertakings, the law was settled that the date of registration is not important. It is the date of carrying out the service that is important. Because as on date, if the service or the sales is carried out, you are an MSME, then you are entitled to protection under the legislation or the benefit under the legislation, because that is how a beneficial statute is to be interpreted. And this law has been well settled since 1993. The successor of that act, my lord, is the 2003 Act, which we now call the MSME Act. Because, my lord, that time we now have a threefold classification. You have a micro industry, you have a medium scale industry, and you have a small scale industry. Small, micro, medium. So that is how, my lord, this act comes in. And, my lord, the benefits are slightly more over here. There are some improvements. One of the major is, my lord, it conceives of a statutory conciliation and arbitration. Section 18 is a two-tier process where under Section 18 of the MSME, you first, Facilitation Council tries to conciliate. If not, you go and arbitrate. And once the process of arbitration is stepped in, it is the law which creates by fiction a contract within the meaning of Section 7. And all the sections of the Arbitration Act automatically applies to the arbitration over there, which has an overriding effect on that. And these propositions of law are well settled. Our High Court is there, my lord, Supreme Court is there. There is no dispute with regard to these propositions of. So, my lord, when we invoke the arbitration under the Facilitation Council, they don't go and appear for the simple reason. They say that the council does not have the jurisdiction to adjudicate their counterclaim, because they stick to a definition that it is only the claims of the supplier, completely ignoring the provision of, my lord, the amendment to the Arbitration Act, that once you are a respondent in that, you can file your counterclaim.
2017.
Millard, I went to the council, I'll tell you, Lord. 2017. But kindly take page 300, Lordship will get that. May 11th, 2016.
Had not yet come.
It came into effect from October 2015.
actually came with retrospective.
Yes, it was the bill. There was a bill and then it became an act. I'll come to that. I'll come to that. Kindly come to page 300.
Yes,
But Milord, there was no doubt before the arbitrator when we took the point under section 16, all of us were aware. Arbitrator for his convenience, I'll come to the section 16 later. Unfortunately, that time Perkins had not come, otherwise we would have that is another aspect, and it's a pure question of law. Lordship will not have to go into all this because Lordship will see the arbitration agreement, it is an unilateral appointment, and they took it. They took this point and they had their own system only to, my lord, make this infructuous or not attempt or create some sort of an imbalance. I'll come to that. My lord, this is a September order. Kindly see, my lord, this is of after presentation of the writ petition. The petitioners have invoked the jurisdiction of Micro Small Enterprises Facilitation Council in respect of payments that are outstanding at the end of the respondent. Mr. Chaudhary, learned advocate for the petitioner, submits that the petitioner may be granted liberty to proceed with the council in accordance with law. Mr. Banerjee, learned advocate representing the respondent, submits that the respondent has a counterclaim against the petitioner and the council has no authority or jurisdiction to decide any counterclaim. The Lordship will see the act. This is Act 3 of 2016 with effect from 20, as on September 2016 the act had come. I give your Lordship the date of the act also. That is why, my lord, but these were not required to, according to him, the liberty prayed for. With effect to the retrospective. But my lord is asking, when did it get the asset? So, my lord, on 2016, it was very much there, but be that as it may, that is also academic. When we went before the arbitrator under section 16, my lord, it was there. Liberty prayed for to the petitioner, if granted, would disable the respondent to raise its counterclaim, and parties should be allowed to agitate the grievance before the arbitrator who has already been appointed in terms of provisions of clause 18 of the contract. Well, clause 18, Lordship will find at page 88. So, my lord, when the hearing of the writ was fixed or it was to be taken up, before that, my lord, they invoked the contractual arbitration. And my lord, I got it recorded in the order of the, kindly see page 88. That point of time, Perkins was not holding field. Perkins is the judgment of, where a clause says that one of the parties will unilaterally appoint the arbitrator or nominate the arbitrator, that is ipso facto void. But that point of time, that came in 2019. Perkins came in 2019. Supreme Court settled that. And all yes, the Amendment Act, Arbitration Conciliation Amendment Act came on 31st. It received assent of the 1st January 2016. And Act of the Parliament got assent of the President on 31st December 2015. That is why, it is the Act number 3 of 2016. So, at page 88, Lordship will find the contractual clause is an unilateral appointment clause. The chairman appoints it. Page 88, volume 1, if Lordship sees. If any time during or after contract period, dispute or differences arise, so and so, same shall be referred to the chairman and managing director or the managing director MD as the case may be for garden leave search. And then this is the clause which was invoked too. If CMD or MD of garden reach so desires, may nominate or appoint another officer of GRSC or a person whom he thinks fit and competent for adjudication. After parking, this goes complete. But be that as it, I am on that. So, my lord, we raise the issue of section 16. Now, kindly have a look at the section 16 order. Well, kindly take page 303 in volume 3. And in fact, my lord, Mr. Banerjee was there right from the arbitration.
Parkins is whose judgment?
My lord?
Parkins is whose judgment?
In fact, I have it. I'll just check it. In fact, my lord, this is a judgment of bench of Justice Lalit and Justice Indu Malhotra. The author of the judgment was Justice Lalit. And subsequently, my lord, after Perkins, my lord, there are other two or three subsequent.
This is after Bharat Broadband or
Prior to Bharat.
Parkins is prior to Bharat Broadband.
That's the first time. Bharat Broadband is it has followed Perkins. It has followed Perkins. I'll also cite Bharat Broadband. Let kindly come to page 303. But I'll not trouble your lordship with the facts, my lord. After the council's name and all, my lord, kindly come to page 304, second paragraph. There had been certain dispute between the parties relating to the execution of the contract. The MEPL claimed sum of 85.71 lakhs to advocates, letter dated 27 January 2016. And my lord, as on that date, this was the only claim which was on record. They did not have any quantification also. On the other hand, GRSC has allegation of non-compliance of the contract fully, and as such, it has a claim against MEPL. At a section 16 stage, this is the position. On prayer of GRSC, in fact, my lord, we filed by a letter before they could file the statement of claim. We filed this section 16. On prayer of GRSC, the chairman and managing director of GRSC has appointed sole arbitrator on the basis of clause 18. Being properly represented through learned counsel, the MEPL appeared and submitted objection which is treated as per its prayer. It is alleged in the application MEPL has filed application before West Bengal State Micro Small Enterprise Facilitation Council to resolve dispute between the parties claiming outstanding dues. Further stated MEPL, this arbitral tribunal has no jurisdiction to adjudicate the matter. In view of the above, the point of jurisdiction is taken up for decision first. It is heard at length on 21st January 2017. Both parties have advanced their respective arguments and referred to various decisions of Honorable Court. Both parties have submitted their notes of argument. Then, my lord, the decisions are referred to. And then kind 306. My lord, the decisions referred to over here, we were cited it, showing, my lord, that under section 18, at that point of time, Supreme Court had not come, but Allahabad High Court Justice Chandrachud, the Chief Justice of Allahabad High Court, had said that section 18 of the MSME Act has an overriding effect. And if there is an arbitration invoked in terms of MSME Act, it will override any statutory. To those effects where the arbitrator. The ratio of the judgments were to those effects. Now, decision with reasons. MEPL as petitioner filed writ petition so and so, which is decided. In the aforesaid writ petition, both parties submitted their same contention as stated above. Considering their submission, Honorable Court has been pleased to opine, and this is quoted directly from Justice Dipankar Datta's order, which I just now read out. At page 306, last 10 lines, the quotation is from that order. But in the writ petition, my lord, it was not even an issue. And Lordship will not find any discussion on the point of law 23A, counterclaim, this claim, nothing. I'll come to that. Then my lord, kindly come to page 307, third para. From clause 18 of the purchase order, it is clear that any unsettled claim, question, dispute or difference arises between the parties shall be referred to chairman and managing director. It's paraphrasing the arbitration clause. The arbitrator, as per section 16, has the power to decide claim and counterclaim. But the facilitation council has power only to decide disputed claim, but not the counterclaim. This is completely erroneous and doesn't even refer to the sections. From the acts and decisions referred by the parties, it is crystal clear that the dispute, that is claim and counterclaim, can only be decided completely by the arbitral tribunal. I can understand this. How do you decide my counterclaim also? But my lord, without prejudice, I had to still file it over there because that time, my lord, I did not know I would get an award over there. The facilitation council is not able to give relief to the counterclaim. So there is no room for complete adjudication in the council. It is well settled principle of law. All disputes should be admitted. These are all, my lord, unilateral statements by the arbitrator, my lord, without reference to any authority whatsoever. But we had to suffer the section 16 order and continue before him, knowing that it's a fake science in there delivered because the arbitration was, my lord, given birth to only to, my lord, harass or, my lord, somehow make the proceeding before the council infructuous. And my lord, kindly see no distinction, my lord, nothing. The decisions are not even dealt with. And my lord, this is the from the 308 last paragraph. My lord, kindly see second last paragraph. Even when we argued, there was no counterclaim on record. During argument, it is submitted on behalf of the respondent. No claim is submitted by the claimant till date of the argument. They have not even raised any claim on me.
Submitted on behalf of the respondent, meaning
Well, they were treated to be the claimant before the arbitrator because they invoked.
Right.
So we became the respondent there.
Right.
I said, what any claim, can they show they have raised a claim on me? In fact, my lord, if Lordship sees, my lord, Justice Dotto's order records, I had made that submission also. Till date, there is no counterclaim, not a single letter that I have a counterclaim against you. Lord, that took birth because of the writ petition, and my lord, perhaps the then advising advocate thought it's a good point to do that. But be that as it may, this is there. So this is, my lord, the section 16 order, which is the subject matter of section 34, which was argued threadbare. Because, my lord, it fell when we were at item that no, if this succeeds, no need to go into the merits. I'll show on merits also. But in fact, the witness, their witness, the claimant's witness, admitted they did not suffer any damages. Just see that question, one single question.
I have not.
1 minute,
argued on
1 minute,
merits.
1 minute.
I have not
No, I am
touched
also
merits.
not arguing
Please,
on
then,
merits.
kindly stop. Kindly
I
have not argued a single thing
I am
on
not
merits.
arguing on merits also.
I have not touched anything
I
on
did
merits.
not get up, Mr.
I did not.
Yes.
Yeah, I've kept it as per the order. I did not argue on merits.
Sir, 614. Kindly have a look at one question. No, I am just giving a, my lord, idea. It's not that, my lord, because repeatedly submissions were made. It's on section 16 only, section 16 only. As if he has a good case on merits. I am just showing why this arbitration was even born. It was supposed to be stillborn. It was born because of, my lord, an oblique motive, my lord, just to frustrate the council's arbitration. Page 640. Kindly have a look. Volume 5. $127. And this is, my lord, happening on 8 December 2017. then do I take it to be your evidence that you have suffered no damages by reason of the so-called incomplete work in the wet basin? No, we have suffered no damage so far, sir. And my lord, the ship was commissioned in July 2013. I am not making, well, this is, I am only saying, my lord, what was the quantum, what was the dispute and all that. I will not make any submission on merits. Now, my lord, section 16 was also one of the ground. So, my lord, when section 34 was taken up before this honorable court, we argued section 16 first. And it was then counsel who was representing, my lord, we agreed that section 16, if this point is successful, no question of going further because the award will go. So on section 16, only two issues were argued. Number one, whether the facilitation council had the jurisdiction to adjudicate their counterclaim. Because when, my lord, the section 34 was filed, Shilpi had not yet come. And my lord, we had, in fact, I remember, my lord, 2 to 3 days we had argued. I had relied on the pre-Shilpi judgments, which were, my lord, of various high courts, which were still holding. And then in course of the argument, my lord, Shilpi was pronounced. So, my lord, armed with Shilpi, we came back. And my lord, Mr. Banerjee, who was then, my lord, he fairly said that after Shilpi, there is very little here. Because now 23A was also by that time, my lord, well known. That I cannot argue on that. But I have another point. And becoming wiser from Shilpi, and that is where they take up the point for the first time. They take up this point that, well, you see, their registration is on such and such date, but the contract is prior to the registration. This is the point which they first time take in the section 34. Well, in course of argument, this is what is argued. Lordship will not find in 34 in the pleading, all that is there. So, my lord, we relied on the 1993 Act's judgment of the Supreme Court that the test is not the date of registration, but the date when the service is rendered. If when that service is rendered, you are an MSME. It's a beneficial legislation, you are entitled to that. Benefits of the statute. That was the interpretation of the earlier Interest on Delayed Payment Act. Shanti conductors, I'll give your lordship that. On that. Then, my lord, following Shanti, and my lord, that is Shanti conductors we cited. And after that, my lord, Shilpi came. So, my lord, formally we cited Shilpi also. Now, my lord, Shilpi takes care of two situations. Number one, MSME has the jurisdiction to decide counterclaim. And number two, this, my lord, section 18 point, my lord, the registration point. This is the ratio of Shilpi. Lordship will take up the Shilpi judgment once. Kindly take it up once. So, Lordship will find that in there. Yeah.
The Shilpi was Kobe. We read Shilpi's.
Yes, yes. Well, I just. Flag number. একটু বলে দাও তো তোমাদের flag numberটা কি আছে আমি ওটা বলে D before date. Well, it should be in flag number D. Flag D নেই এখন পড়েছে তারপরে জমা দিয়ে Oh, I see. Well, it is, I believe they are flag D. Well, they will flag it and give it, well, this is flag. It should be flag. Justice Bhattacharya judgment দেখাচ্ছি এটা দেখি. Kindly see in para 7 of the judgment, which should be, my lord, in it is an SCC online edition, my lord, page 10 of that. Or, my lord, page.
Yes, we've got it.
797 of the SCC report. Para 7, third issue. Whether counterclaim is entertainable in the arbitration proceeding held pursuant to the provision of so-and-so and the MSMED Acts. The IDPSC is the predecessor act, interest on delayed payment for small scale and some industries. I'll give you ancillary industrial undertaking. That was the predecessor of the MSME. Now, this issue number 7C is answered. Kindly straight away come to para 33. From a reading of section 18.3 of the 2006 Act, it is clear when the conciliation initiated under subsection 2 of section 18 of the said Act is not successful, the Council shall either itself take up the dispute for arbitration or refer to any institution for arbitration. Further, 18.3 of the Act also makes it clear that the provisions of 96 Act are made applicable as if there is an arbitration agreement between the parties under subsection 1 of section 7 of the 96 Act. Section 23 of the 96 Act deals with the statement of claim and defense. Section 23(2)(a), which gives the right to the respondent to submit a counterclaim or plead set-off with regard to the claims within the scope of the arbitration agreement, is brought into statute by amending Act 3 of 2016. If we look at the statement of objects and reasons of the amending Act, same is also enacted to provide for speedy disposal of cases relating to arbitration with least court intervention. Clause 11 of the bill, it was initially in the form of the bill, later became an act, by which subsection 2A was proposed to be inserted, states that subsection 2A was intended to be given an opportunity to the respondent in support of his case to submit his counterclaim or a set-off if such counterclaim or set-off falls within the scope of arbitration agreement. When section 18.3 makes it clear that in the event of failure of the council under 18.2, if proceedings are initiated under 18.3 of the 96 Act, the provisions of 96 Act are not only made applicable, but specific mention is made to the effect as if the arbitration was in pursuance to an arbitration agreement where referred to in subsection 1 of 7 of the 96 Act. When there is a provision for filing counterclaim and set-off, which is expressly inserted in section 23 of the 96 Act, there is no reason for curtailing the right of the respondent for making counterclaim or set-off in the proceedings before the facilitation council. It is also further to be noted that if we do not allow the counterclaim made by the buyer in the proceedings arising out of claim by the seller, it may lead to parallel proceedings before the various fora. On one hand, in view of the beneficial legislation, seller may approach the facilitation council for claims in the event of failure of payment by the buyer under provisions of the Act. At the same time, if there is no separate agreement between the parties for any arbitration in a given case, buyer may approach the civil court for making claims against the seller, or else if there is an agreement between the parties for arbitration. So, but this has also been taken note of by Justice Bhattacharya. I'll come to that. Because at that point of time, to be very fair, because of the drastic nature of the MSME Act, people were trying to avoid the facilitation council. This was a very common ground, saying that council cannot have jurisdiction over my counterclaim. Because the reference provision was dispute by the supplier. So the interpretation was only the dispute of the supplier can go, not the dispute of the principal, not the dispute of the buyer. So these were there, and there were some divergence. More or less, high courts were ad idem that it's but there were a few contra views. But Bombay, Allahabad, as far as I can recall, and prior to Shilpi, Justice Chandrachud's judgment, sitting in the Allahabad division bench, was one of the holding the field in the sense at greater persuasive value at that point of time. So, my lord, this is the first ratio of Shilpi. So, my lord, the main point on which the section 34 was filed, my lord, kindly see the 34 application grounds. Because, my lord, you cannot, now it is also well settled, you cannot take any other ground if you have not taken it in the 34. Because, my lord, it amounts to, you cannot even amend the section 34. I'm sorry, my lord. I'm sorry. I'm sorry. Yes, yes. I am under 34. They are opposition.
He is also confused.
Opposition.
Like
Yes, my lord.
I was in the morning confused. He is
My lord, it is because, my lord, we had argued this in the other matter, my lord. They had the 34 and I did. Same point. Works contract. Same point. In fact, my lord, in the previous division bench, my lord, when Justice Sen was presiding, where, my lord, that episode happened, my lord, we were thinking, my lord, this was expedited and we were thinking that whether in clause 13 we can give consent and get that also transferred.
Because consent. I am a PSU. I have to take instruction. He wants
that it is the same point, works contract. But be that as it may, if we can get the law settled from the division bench, my lord, as and when I am lucky to get a chance over there at the second innings, my lord, but my lord, I'll suffer the same fate, my lord. We can argue, but we have no manner of control as to how judges will write judgments. That is
instruction
beyond the control.
It's a very fair suggestion because I will take instruction. I'm a PSU. I cannot give my consent. Lordship, no.
Hey, Your Honor, be that as it may.
I can't give the consent. I'll obviously take because without anything here will have a bearing in there. That's fixed on 90.
Yes. So section 34, whether the primary ground was, well, on merits, the other grounds were there. One of the primary ground is you have not suffered any damage. You have not suffered any damage. Your witness has admitted that. You have released the performance guarantee. You did not have any claim during the warranty period also. The ship has performed fantastically. You don't have a claim. How can you suffer a damage? Well, their claim was in the nature of in future I may suffer damage. I'll show that. I'll show that. And that is the basis on which the arbitrator has passed the award and does not refer to that question at all. Though, my lord, we argued it. That is our main trump card. He conveniently avoids that. So, my lord, this is, and these are happening, my lord, at that point of time. Then, my lord, Perkins come. But I must be candid, my lord. We did not, Perkins, my lord, there was a
take instruction on that.
We will,
Clause 13, I'll take instruction. He's there.
My lord, Perkins had come, but my lord, this was a point which was settled, so we did not go into that. Perkins was not gone into even before the learned single judge because, my lord, this was sufficient. So, my lord, as I said, my lord, in all fairness, my lord, Mr. Banerjee, who was then arguing, my lord, we did not have much argument because after Shilpi, this paragraph, there was nothing further left so far as that is concerned. So, my lord, now the second point, that what is the effect of a registration subsequent to the contract. Now, my lord, so far as that is concerned, that is also, my lord, taken care of because, my lord, this was the point which came from the bar when the argument started and Shilpi came in, my lord, it sort of intervened. My lord, kindly come to the Shilpi judgment, my lord, para 42.
That we have followed, Mr. Chaudhary. It's the date of performance, date of supply.
And, my lord, this is para 43, Lordship will find reference to Shanti conductors. This is under the payment to small scale and ancillary industrial undertaking. The goods of services can be taken as the supply of goods and services can be taken as the relevant date. Even before the prior statute also, there was a precedent that it's a beneficial legislation, I can give it. But in Shanti conductor, my lord, the person did not get the benefit because in that case, the services was also later. Or rather, services were earlier to the registration. So they did not. The Supreme Court held we could have given you the benefit if it would have been later. That's in Shanti conductor. But Shilpi, my lord, settled the law. Now, my lord, following Shilpi, my lord, there is another decision of Gujarat. My lord, lordships have seen that. It's the same ratio. Now, my lord, kindly come to the 2025 judgment which my learned friend said. But I am not separately again reading Gujarat, my lord. It is It's on the same line. Also, there is no dispute. My learned friend will again object that it's on merits. Well, the work that we performed was after the registration. There is no dispute with regard to that. The 314 is the document, ballot which shows whatever work has been performed.
I have argued on merits.
Yes, yes, I know that. I am not saying on merits. I qualified it. I said work was performed after the registration. Well, kindly takes the 2025 judge. Paragraph 3. But before para 3, Lordship will find para 2 also. This was a point which was taken at the first instance. Here, my lord, this was taken only, my lord, in course of argument of section 34 from the bar, this registration aspect. It was neither raised before the council nor raised anywhere else, and subject to correction by my learned friend, not a part, not raised anywhere in any other proceeding, but taken up from the bar, in course of argument from the bar. Then, my lord, para 3. We have examined the text, context, and purpose of the Act to arrive at the decision that Section 18 is not restrictive and is a remedy for resolution of dispute, and as such, it is kept open-ended to enable any party to refer the dispute to seek redressal. Any party, not restricted to supplier. This is straight away the ratio even of 2025. For reasons to follow, we reject the submission that any party to a dispute is confined to a supplier who has filed a memorandum under Section 8. We have also explained that the issues that have arisen, that in the decisions of Shilpi and Gujarat, so and so, were very different from the issue that has arisen from our consideration. First note. What is the difference? I'll show you a lot. However, for clarity and legal certainty, we have directed the appeal be placed before the Honorable Chief Justice of India, referring the matter for 3 judges for an authoritative pronouncement. Then, my lord, the facts are gone into. I'll come to that later. But, my lord, kindly see, my lord, even 2025 is ad idem on the point, so far as the issue number 3 in Shilpi is concerned. That claim would include a counterclaim, and any party can raise a dispute to the council, and is not restricted to a supplier only. Para 3 is clear. Now kindly come to (15.4). This decision chronologically deals with all the cases. So Shanti conductors is dealt with, my lord, in para 15, and then, my lord, they summarize the ratio of Shanti conductors. 15.4 at page 455 of the SCC report. The ratio of the decision in Shanti conductors can be formulated as follows. Even if contracts are entered into before the commencement of the repeal statute, the liability to make payment under Section 3 and to pay interest under 4 and 5 and to recover the amount under Section 6 will arise if the supplies are made subsequent to the enforcement of the statute. The incidence of liability under the repeal statute is supply of goods or rendering of services. When the date of contract is neither referred to nor made an incident for fastening the liability under the statute by way of judicial interpretation, courts cannot treat the said date as the date for fastening the liability. The existence of statutory liability depends on the language employed in sections 3 to 6 of the statute. To hold that the liability of the buyer to make payment shall arise only when the contract for supply was entered into subsequent to the enforcement of the act will defeat the purpose and object of the beneficial legislation intended to protect small scale and ancillary industrial undertakings. Well, the idea is that small scale industries receive their payment promptly. Otherwise, there is a deterrent of, my lord, 2% above the bank interest, and, my lord, that's the deterrent. Then, my lord, there is a history of that. I will not trouble your lordship. So, my lord, so far till now, 2025, my lord, they are ad item. I have shown what paragraph 3 says, so far as counterclaim is concerned. Now, kindly come to paragraph 25. Whether registration is a necessary precondition to referring a dispute under section 18 of the Act. The question that we are called upon to answer is whether the reference to the Facilitation Council under section 18 of the Act is impermissible if the enterprise is not registered by filing a memorandum under section 8 of the Act before the contract is executed. This issue was not formulated, discussed, and decided in any other judgment of this court, including two substantive judgments under the Act, Shilpi Industries or Mahakali Foods. In these two judgments, it is worth mentioning such an issue was neither formulated nor discussed. We will explain this in detail while discussing the facts and ratios of these judgments. Apart from the submission of the appellant that the issue arising for our consideration is covered by the decision in Shilpi as approved.
Mr. Chaudhary, these paras were placed by Mr.
Very well. I'm sorry. So, my lord, the essential finding in the 2025 cases, as if Shilpi, Mahakali, Gujarat, and others are in the nature of arbiter, because the issue was not directly raised. But, my lord, I have shown that all the three cases, lordship will find there is elaborate reasoning following Shanti conductors. My lord, the ratio seems to be well settled. And, my lord, there are threefold limbs to this ratio. Number one, it's a beneficial legislation. Number two, the incidence of payment within a certain period of time after the bill is presented is, my lord, the attracting section is not based on the time when you enter into the contract, but the time when you give the supply or services. And number three, well, from 1993, the predecessor act also, the law has been holding the field for the last 30 to 35 years that it is you get the benefit of this act if at the time of giving the service or making the supply, you have registration under the act. From Shanti conductors, my lord, the law is now, it has continued. Tomorrow, larger bench may say otherwise. But, my lord, I am on a point that till date, as we argue, my lord, the law is well settled. Now, my lord, kindly come to this. But kindly straight away come to, I'm sorry.
Yes, when will you continue?
Well, I can continue tomorrow if Lordship takes it up at 2 p.m. My lord, I must be candid. My lord, I am on legs before the other
Lordship has
division.
kept, my lord, the really matter with tomorrow, my lord. really, Millard, Mr. Bachawat, Millard, that dismissal of 12A, Millard.
No, I am praying if Lordship takes it up at 2 o'clock. In the morning, Millard, I am on legs before.
Mr. Chaudhary, roughly how long you'll take?
Another maximum half an hour, not more.
You want some time for
Millard,
reply?
he will cite judgments of
Very well. Then tomorrow 3:30.
Very good.
Tuesday 3:30 safe, no problem.
Right.
Mr. Ghosh, learned senior counsel, appearing for the appellant, begins and concludes his submission, his opening submission, Koro. Paragraph, Mr. Chaudhary, learned senior counsel, representing the respondent, begins his argument but does not conclude. Paragraph, list this matter once again, Kalke date thou on such and such, marked 3:30 p.m.
judgment দেখাবে তো 8 ঘন্টা হয়ে যাবে
আমার আর কি জাজমেন্ট আছে দুটো জাজমেন্ট দেখো
জাজমেন্ট যে রেফার করলো তার সেটেল ডিস্ট্রিক্ট ফলো বলছে সেকশন 34 এ কিছু বলেনি আমি তো খামে যাচ্ছে আমার 34 তো নেই না না আমি অপোজিশন অপোজিশন ওই দুটো একসাথে হচ্ছে তো কোনটা অপোজিশন আর কোনটা একটা ওই সব্যসাচী জাজমেন্টটা ওয়ার্কস